and our democratic system are at stake. Let us all take heed of the seriousness of this challenge and invoke the divine guidance of the Almighty God to enlighten our minds and guide our conscience in discharging faithfully our sacred duties. May God provide us with sufficient physical strength, intellectual keenness, and moral courage to render justice in the case before us on the basis of the law, our honest perception and understanding of the facts, and in accordance with the dictates of our individual conscience. Thank you very much.
Mr. President.
You have the floor, Leader.
Mr. President, in accordance with the rules of procedure on impeachment trials, may we ask that the parties and/or their respective counsel be directed to enter their appearances?
We are ready to receive the prosecutors of the House of Representatives' appearances for the prosecution. Please proceed. We suggest and request that all lawyers representing the House of Representatives will enter their appearance in this court to be subject to the rules of this court.
Yes, Mr. Senate President, ladies and gentlemen of the Senate, good afternoon. Respectfully appearing for the House of Representatives Prosecution Panel, my name is Neil Tupas Jr. of Iloilo.
For the prosecution, Raul Dasa, Deputy Speaker, 1st District, Moran Samar.
Conditionally, Marlene Primicia Sagabas, 6th District, Province of Pangasinan.
For the prosecution, Your Honors, George de Agabao, 4th District, Isabela.
Good afternoon, Your Honors. Respectfully appearing for the prosecution, my name is Arlene Bagao from the party list Bayan.
Rodolfo Farinas, 1st District of Ilocos Norte.
Elpidio F. Barsaga Jr., representing the 5th District, the 4th District of the Province of Cavite, the city of Dasmariñas, appearing as public prosecutor.
Respectfully appearing, Your Honors, Neri Javier Colmenares for Bayan Muna Party List.
Attorney Reynaldo Umali, 2nd District, Oriental Mindoro, Your Honors.
Good afternoon, Mr. Presiding Justice, Your Honors. Respectfully appearing for the House of Representatives, Representative Sherwin Tugna, Citizens Battle Against Corruption.
Joseph Emilio Ginaldo Abaya, 1st District, Cavite.
Good afternoon, Your Honors. I am Attorney Mario Luza Bautista, respectfully appearing as private lead prosecutor for the House of Representatives.
Good afternoon, Mr. Senate President and Your Honors. Arthur D. Lim, respectfully appearing as private prosecutor under the control and supervision of the public prosecutors, Your Honor.
Good afternoon, Your Honors. I am Attorney Jose F. Justiniano, appearing as private prosecutor under the direction and control of the public prosecutor.
Your Honors, we also like to manifest that we filed a written entry of appearance for some or additional private prosecutors, namely Attorney Joseph Jomer Perez, Attorney Winston Hines, Attorney Frederick Ballestero, Attorney Ernesto Biovicente, and Attorney Clarence Handok. Thank you
the chair, the presiding officer of this court would suggest that the individual private prosecutors must enter their appearance personally so that their appearance is fully recorded.
Yes, Mr. Senate President, they are present today, and they can enter their appearance personally.
Good afternoon, Mr. Senate President. Good afternoon, Your Honors.
Proceed.
I'm Attorney Winston Hines, respectfully appearing as private prosecutor under the control and direction of the Honorable Public Prosecutors.
Good afternoon, Your Honors. I am Attorney Ernesto V. Vicente, appearing as private prosecutor under direct control and supervision of the House Prosecution Panel.
Good afternoon, Your Honors. I am Attorney Clarence Handok, respectfully appearing as private prosecutor under the direct control and supervision of the Honorable Public Prosecutors.
Good afternoon. My name is Frederick Ballestero, appearing as private prosecutor.
Good afternoon, Your Honors. I am Attorney Joseph Jomer Perez, respectfully appearing as private prosecutor.
Anyone else? Is that all?
It's all, Your Honor.
Thank you. The appearances for the prosecution are hereby noted under Rule 13 of the rules of this chamber. Counsel for the prosecutor shall be under the control and supervision of the panel of prosecutors of the House of Representatives. They are entitled to participate in the presentation of evidence, but arguments bearing on questions of law and issues in this hearing shall be done by the panel of prosecutors representing the House of Representatives who are members of Congress. The appearances for the defense, please state your names and capacity in which you appear.
Kagalang-galang na Pangulo ng Senado, mahal naming miyembro ng Senado, magandang hapon po sa inyong lahat. This is Retired Justice Serafin Cuevas, Your Honor, appearing for the respondent Renato Corona, Your Honor. And for that purpose, Your Honor, may we be allowed to state for the record that the Honorable Justice, Chief Justice Corona is here pursuant to the invitation of this honorable body. May we ask him to stand, Your Honor?
Thank you, Mr. Chief Justice.
We are making of record, Your Honor, that we made him appear in order to show our respect and his respect to this honorable body and to show to the entire world, Your Honor, that he is not canceling anything. He is prepared to enter his defense and convince this honorable body that he is entitled to an acquittal of the charges against him, Your Honor.
Thank you.
Now, in addition to this representation, Your Honor, may we also put on record that he is entering a plea of not guilty to all the charges embodied in the complaint for impeachment, Your Honor.
Thank you.
Now, we also have been here, Your Honor, the rest of the other members of the panel, most of them are signatory to the very answer we have made, Your Honor. In accordance with the rules of pleadings, Your Honor, there seemed to be no necessity for them to make an entry of appearance. But nevertheless, Your Honor, nevertheless, we have made an entry of appearance in writing, Your Honor, which is already a matter of record. May I ask that they be recognized, Your Honor, the rest of the other members of the defense panel?
What's the pleasure of the gentleman from Iloilo, Senator Zero?
Just a point of order, Mr. President.
What is your point of order?
The direction of the chair is for appearances, not for manifestations on other extraneous matters.
Well
Thank you,
taken.
Mr.
Please, counsel, ask the other members of the defense panel to personally enter their appearances for the record.
We will willingly do that, Your Honor. Thank you, Your Honor.
Good afternoon, Your Honors. Jose Roy III, entering his appearance in behalf of Chief Justice Renato C. Corona.
May it please Your Honors, I'm Jacinto Jimenez. I respectfully appear as counsel for Respondent Chief Justice Renato C. Corona.
Good afternoon, Your Honors. I am Joel Budigon. I'm appearing as defense counsel for the respondent.
Eduardo de Los Angeles, co-counsel for the Chief Justice.
Good afternoon, Your Honors. Tranquil Salvador III, appearing for Chief Justice Corona.
Good afternoon, Your Honors. Dennis P. Manalo, appearing as defense counsel for the Honorable Chief Justice Renato C. Corona.
Good afternoon, Your Honors. I am Attorney Noel B. Lazaro, respectfully appearing for the defense.
Good afternoon, Your Honors. I am Ramon S. Esguerra. I'm appearing as co-counsel for the respondent, Chief Justice Renato C. Corona.
A pleasant day, Your Honors. Respectfully appearing for the Chief Justice Renato C. Corona, I am Attorney Rico Paulo Arquicho.
Your Honors, for the defense, Herman Q. Lichop II, for Chief Justice Renato C. Corona.
Anyone else? There being none, the appearances for the defense are hereby noted. Pursuant to Rule 9 of the rules, let it be made of record that the Chief Justice Renato C. Corona has entered his appearance by counsel, and that he is personally present in these proceedings. Majority Floor Leader.
Thank you. Mr. President, on December 14, 2011, the court, pursuant to Rule 7 of our rules, adopted Senate Impeachment Court Resolution Number 1, providing that summons be issued to the Chief Justice Renato C. Corona to answer to the articles of impeachment. The summons was served on the Chief Justice on December 15, 2011 by the Sergeant-at-Arms, who made the return under oath before the Secretary on December 19, 2011. Mr. President, I move that the said return be entered at large on the records in compliance with Rule 8 of the rules.
Is there any objection? Chair hears none. There being no objection, the motion is approved.
Mr. President.
Majority Floor Leader.
Thank you, Mr. President. As stated in the January 9, 2012 notice of the presiding officer, copies of which were served and duly received by the parties, we are to consider as part of the day's business the motion for preliminary hearing filed by the defense on December 29, 2011, and the comment thereon filed by the prosecution on January 9, 2012. However, after the issuance of the notice, the defense filed on January 12, 2012, a motion to admit reply to comment, alleging that, quote, there are certain inaccuracies in the comment filed by the complainants, end of quote, to its motion for preliminary hearing, and praying that the reply to comment be admitted. Before proceeding, therefore, Mr. President, to the consideration of the motion for preliminary hearing, as we have previously informed the parties, I move that we first consider the said motion to admit reply to the comment of the defense.
Is there any objection? There being none, we shall now consider the motion to admit reply to comment.
Mr. President, I move that the presiding officer rule on the motion to admit reply to comment.
Is there any objection to the motion to admit reply to the comment? There being none, The chair rules to grant the motion.
Thank you, Mr. President.
The Majority Floor Leader.
I now move that we consider the motion for preliminary hearing of Chief Justice Renato C. Corona filed on December 29, 2011.
Is there any objection? There being none, the motion to consider the motion for preliminary hearing of Chief Justice Renato C. Corona filed on December 29, 2011 is approved.
Mr. President, I move that we dispense with the reading of the motion in full and ask the Secretary to just read the prayer.
The Secretary shall now please read the prayer of the motion.
Prayer. Wherefore, it is respectfully prayed that 1. A preliminary hearing be held on the affirmative defense that the verification of the verified complaint for impeachment is fatally defective. 2nd, thereafter, the verified complaint for impeachment be dismissed. Makati for Pasay City, December 29, 2011, respectfully submitted by Jacinto D. Jimenez, signed Counsel for Chief Justice Renato C. Corona.
Mr. President, if I may.
Floor Leader.
Thank you, Mr. President. In summary, the motion prays that a preliminary hearing be held on the affirmative defense that the verification of the verified complaint for impeachment is fatally defective and that thereafter the verified complaint for impeachment be dismissed. The motion alleges the following. The verified complaint for impeachment lacks the proper verification because only 4 copies were made available at the time it was signed, and because its text consists of 57 pages with 34 documents consisting of 131 pages annexed to it, and as such, it was physically impossible for the 188 members of the House of Representatives to have read, understood, and evaluated the same. There was a PowerPoint presentation of the verified complaint for impeachment, but the signatories signed it before the conclusion of the PowerPoint presentation, which was aborted. The Chief Justice claims that since the verified complaint for impeachment lacks a proper verification, it should be treated as an unsigned pleading which produces no legal effect and therefore should be dismissed. Upon the other hand, the prosecutors submit that the filing of the verified impeachment complaint by 188 members of the House of Representatives is in accordance with the House of Representatives' exclusive power to initiate all cases of impeachment in line with paragraph 4, section 3, article 6 of the Constitution. They aver the following. The verified impeachment complaint is verified because on its face there is a verification under oath which is signed by 188 congressmen, which is more than 1/3 of all of the members of the House of Representatives. The verified impeachment complaint was sworn to before the Secretary General of the House of Representatives, who is a duly authorized officer to administer the oath. A verification is sufficient when it is signed and sworn to by a parties who has sufficient knowledge and belief as to the allegations therein. In this instance, the matters stated in the impeachment complaint were well known and familiar to the 188 congressmen who signed the same. The Supreme Court has, in decided cases, been liberal in construing the word reading in relation to the verification requirement. There is a strong presumption of regularity and validity in the discharge of the House of Representatives of their official duties, including that of filing of the verified impeachment complaint, which has not been overcome by the allegations of the Chief Justice. Article 11, Section 3(4) of the Constitution does not require verification by all the complainants. It speaks of filing by at least 1/3 of the members and not verification by all of the said members. Thus, it is sufficient that there is a verified complaint by at least one person and that such complaint is filed by at least one-third of the members of the House of Representatives. Chief Justice Corona's objection to the verified impeachment complaint is moot since it has been transmitted to the Senate for trial. Chief Justice Corona's objections to the verified impeachment complaint have been waived by his public pronouncements that he is willing to face trial in the Senate and by his filing of his answer in motion for preliminary hearing. And a verification is a formal and not a jurisdictional requirement. Mr. President, the reply to comment filed by the counsel for Chief Justice Renato C. Corona, on the other hand, alleges the following. The Senate is an impeachment court and has the power to determine if the power to impeach has been made by the House of Representatives in accordance with the provisions of the Constitution. It also alleged that the Senate has an impeachment court, has acquired jurisdiction over this case, and it has the jurisdiction to pass upon the validity of the complaint. In order not to deny him due process, the Chief Justice should be allowed to prove his allegation that these verification requirements under Paragraph 4, Section 3, Article 11 of the Constitution were not complied with. The requirement for a valid verification of the complaint cannot be dispensed with, and the issue raised in the motion is not yet moot, and the Chief Justice is not precluded from raising the issue of jurisdiction even if he alleged other affirmative defenses for the dismissal of this case. Mr. President, I move that should the parties have any other additional grounds or arguments after the summary not contained in the pleadings excluding evidentiary matters, I move that the parties be allowed to present their respective arguments, Mr. President.
Is there any objection? There being none, the motion is approved.
It's a procedural matter, Mr. President, before we approve the motion. Is there a time limit as to the presentation?
Gentleman from Pampanga.
Yes, is there a time limit, Mr. President, to the presentation of both the parties?
We limit it to the, leave it to the discretion of the presiding officer, Mr. President.
Thank you. We will defer to the Senate President, Mr. President, as regards the time limitation.
I repeat, is there any objection? There being none, the motion is approved. The movant shall now present its arguments for a period not exceeding 5 minutes, after which the prosecution may present its arguments also for a period not exceeding 5 minutes. Neither party shall be allowed to present evidentiary matters on this interlocutory matter. Proceed.
Thank you, Mr. President. Our answer, Your Honor, filed in accordance with the instruction of this Honorable Impeachment Court, carries with it the affirmative defense as allowed under the rules of procedure and under the rules of this impeachment court, Your Honor. We stated...
Just a minute. For the record, the one arguing for the defense is the former Justice of the Supreme Court, former Justice Serafin Cuevas.
Thank you, Your Honor. In our answer, Your Honor, we challenge the validity and the legality of the proceedings in connection with the initiation of the impeachment proceeding, of the impeachment complaint, Your Honor. We therein stated that it is not only necessary that the complaint be verified, but there must also be a showing that there was a determination of probable cause prior to the affixing of the signatures on the said impeachment complaint, Your Honor. Why do we say so, and what is our authority for the purpose? No less than the Honorable former Chief Justice Panganiban states that in any case similar to this, the respondent is entitled to the protection under the rules. And what does that carries with it? That requires or carries with it notice and hearing. Our query is, was there any notice sent to the Chief Justice in connection with the filing of this complaint? There is none. Is there any opportunity given to him in order to prove his point in connection with the alleged complaint? There is none also. Now, what is the status, therefore, of this complaint? Now, the Supreme Court had already ruled on this, pursuant to the Francisco ruling, that any and all proceedings conducted in connection therewith is a nullity, and therefore, respondent is entitled to a dismissal of the complaint amount of due process, because being an accused or being charged with the alleged offense of stated in the complaint, he is entitled to due notice. And what is the requirement with respect to due notice? He must be given notice, due process. He must be given notice, and he must be allowed to be heard in connection. So notice and hearing is an indispensable requirement for purposes of acquiring jurisdiction over this case. Now, the signing is but only a very significant matter. They claim it is merely what we call a procedural defect, if ever there is any. We do not subscribe, and we are sorry to announce that that is not true insofar as impeachment proceedings is concerned. Because what confers jurisdiction to this honorable court is the validity or correctness or the legality of the impeachment complaint. We ask, is the impeachment complaint valid? Our answer is no. Is it in accordance with the Constitution? Also no. Were the procedure laid down by the rules in connection with due process followed? Also no. We have examined the report of the Secretary of the House. We see no statement therein relative to the conduct of any proceeding being held in connection with the determination of probable cause. Now, it may be said, but in accordance with the rule of procedure, it is only in two cases where determination of probable cause may be necessary. First, when the impeachment proceedings is initiated by a member of the House under oath. Second, where the impeachment proceedings is instituted by a private citizen upon endorsement of a member of the House. And the third one is when the impeachment proceedings is initiated by not less than one-third of the entire membership of the House. Now, if in the two cases due process requires that there must be a determination of probable cause, what is there to prevent? Or why is it not necessary in connection with an impeachment proceeding initiated by one-third of the House? Does it mean to say that simply because one-third affixed their signature, assuming they did, does it mean to say that that validates already an illegal or an impeachment complaint violative of the Constitution and our laws? Our answer is no, Your Honor. Because due process is required not only by law, but by the Constitution that must be afforded to the person impeached. Here, we are impeaching a personality, no less than the Chief Justice of the Republic of the land, the head of the Judicial Department of the government. And now, if it is a simple,
May 5 minutes.
now they were asking your,
May I request the good counsel to wind up his argument?
yes, Your Honor, we will. Thank you, Your Honor. Now, what then is the validity of the impeachment proceedings that were undertaken prior to the transmission to this honorable body of the impeachment complaint? Null and void. Any and all proceedings conducted thereunder is a total nullity. Now, if that is so, that is why we were insistent, Your Honor, with due apologies, that this matter be dealt with, discussed, and passed upon in order to determine whether we should still proceed with the trial of this case. They say, Your Honor, or there is a claim that this is merely dilatory. How will it be dilatory? That this is merely for purposes of delay. Precisely, we are accelerating the disposition of this case.
Is it the position of the counsel that an impeachment case initiated under paragraph 4 of section 3 of article 11 requires all the members of Congress joining in filing the articles, the verified complaint, to verify also the complaint?
Well, verification is not...
No, I'm asking you a question.
Yes, Your Honor.
Is that the position of counsel?
No, our position, Your Honor, is the law requires verification, but in addition to verification, Your Honor, the more important element is the element of due process. Was he notified?
Yeah.
Was he given the opportunity to prove
Yes.
the non-existence of probable cause? If the answer is yes, Your Honor, then that is an entire proceedings that is not sanctioned by the Constitution and by the law.
We respect the opinion of the distinguished counsel, but under our rules, the rules of court is only supplementary to the rules of the House and the rules of the Senate. And if the process in the House is in accordance with
May I close, Your Honor, with a statement to the effect that we are not delaying the proceedings before this case. We are not trying to lengthen the duration during which proceedings may be undertaken, but we were merely asserting a right to which every Filipino, not only the Chief Justice, is entitled, and that is due process in accordance with the Constitution.
We take note of that.
Thank you, Your Honor.
You're welcome. The prosecution panel may now proceed to use their 5 minutes to argue their case.
Yes, Mr. Senate President, may we request that our counsel, Attorney Mario Bautista, be recognized to argue for the prosecution?
As the chair said, only members of the House of Representatives can use the parliamentary forum to argue a case.
Besides,
so the argument must be presented by members of the House of Representatives acting as prosecutors.
In that case, Mr. President, we will argue for the prosecution. The position of the House of Representatives, and would like to manifest that the Speaker of the House is here, Speaker Belmonte, and the Majority Leader, Congressman Gonzales. Under the Constitution, Article 11, Section 3, Paragraph 1, the House of Representatives shall have the exclusive power to initiate all cases of impeachment. And in the same section, subparagraph 6, the Senate shall have the sole power to try and decide cases of impeachment. To us, Your Honors, the House initiates, the Senate tries and decides the case. The verification is part of the initiation process. The Constitution, Section 3, Paragraph 4 says, in case of verified complaint or resolution of impeachment filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. Did the members of the House verify the complaint? Yes. Does that constitute one-third? Yes, in fact, more than one-third. One-third of 284 is only 95. 188 signatures appeared. 13 more, but we did not anymore consider the 13 because they signed only after we already filed the Secretary General. And so, it is very clear on its face, on the face of the complaint, that it was verified by 188 members of the House, and it went through the plenary, Your Honors. After the signing, verification, it went to the plenary at 7 o'clock in the morning, 7 o'clock in the evening, and it was approved in the plenary. In fact, we have a journal, and under the rules on impeachment of the House, Section 13, it says that in this case, which means the verified complaint, shall be endorsed to the Senate in the manner as an approved bill of the House. Meaning, even in ordinary legislation, like for example, the Senate gives conclusive effect to the bill of the House, how much more if it is already acting in as a constitutional body, the House, when it transmitted the articles of impeachment. We have this journal, Your Honor, and journal of December 12, and it says here, upon query by the Congressman, Secretary General Yap clarified that the signature and verification process commenced at the Andaya Hall and ended after an hour, and then continued at her office, and that before she proceeded to the session hall, Representative Tugna was the last signatory. It is the position of the House, Your Honors, that this is conclusive because this is the journal of the House. And in fact, there's a precedent. The precedent of this during the time of President Erap in 2001, and I can remember I was a practicing lawyer at the time when the Honorable Senator Joker Arroyo stood up for the House, that the House, within its own sphere, is supreme. The same thing that the Senate, on its own sphere, is also supreme, meaning the House initiates, the Senate tries and decides. We submit, Your Honor. Thank you.
Dirty floor leader.
Mr. President, I move that the presiding officer rule on the motion for preliminary hearing.
Hearing. Is there any objection?
Yes, not hearing.
Before His Honor rule on the motion, Your Honor,
May
I wonder whether we can be
May I
permitted.
request the council to address the chair first?
Yes, Your Honor.
What is the pleasure of the council?
May I place on record, Your Honor, the support of our plea that there was no valid initiation of the impeachment complaint in this case. We are quoting from the very provision, from the very contents of the disposition of that case. This is by then Chief Justice Panganiban. The due process clause in our fundamental law is a condition sine qua non that cannot be ignored in any proceedings, administrative, judicial, or otherwise.
Mr. President, Mr. President,
The majority floor leader.
I believe we have a pending motion. I also believe that we should just go on, and we have already heard the arguments. We have summarized the arguments. We have read through the arguments in the last so many days. We understand the points being raised by both parties. So we leave it to the presiding officer to give the ruling, Mr. President.
We are just pleading, Your Honor, we are not demanding it as a matter of right. We knew our own limitations, but we rely on the magnificence and liberality of the presiding officer to further hear our authority on the point when we stated.
You are given 3 minutes.
Yes, Your Honor. it is deemed written into every law, rule, or contract, even though not expressly stated therein. Hence, the House of Representatives rules on impeachment, insofar as they do not provide the charge official with notice and opportunity to be heard prior to being impeached, are also unconstitutional. If it is unconstitutional, no rights thereunder are required. Therefore, the entirety of the proceedings is likewise null and void. Now, may we also be allowed to place on record the statement by the Honorable Justice Inares Santiago. It says, the complaint suffers from yet another serious law, because no rule is better established under due process clause of the Constitution than that which requires notice and opportunity to be heard before any person can be lawfully deprived of his rights. The Constitution says, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the protection of the law. The question of sufficiency on the complaint form may again be brought before the Senate by way of proper motion, and the Senate may deny the motion or dismiss the complaint depending on the merits of the motion raised. After the Senate shall have acted in due course, each disposition of the case may be elevated to this court pursuant to its judicial power. Submitted, Your Honor. Thank you very much for the opportunity
Thank
to
you,
read this on
Counsel.
record.
Thank you.
Thank you, Your Honor.
We will take note of your argument. Now the chair will make a ruling. This is without prejudice to the issuance of an extended resolution of this court within 48 hours. It appearing that the filing of the verified impeachment complaint was made in accordance with paragraph 4 of Section 3, Article 11 of the Constitution, there's no more need for a preliminary hearing to receive evidence on this matter. The Senate should forthwith proceed, for that's the mandate given to us by the Constitution, with the trial of the Chief Justice Renato Corona on the articles of impeachment in accordance with the mandate of the Constitution. In view of the foregoing, the motion for preliminary hearing filed by the Chief Justice Renato Corona is denied for want of merit, so ordered. Just the floor, Leader.
Mr. President, may I now ask that the parties be directed to present their opening statements.
Is there any objection? There being none, the motion is approved. The prosecution shall now present its opening statement for a period of not more than 10 minutes, after which the prosecution may present its arguments also for a period of not exceeding 10 minutes. Proceed.
Mr. Senate President, ladies and gentlemen of the Senate, good afternoon to all of you.
Kindly identify yourself.
My name is Niel Tupas Jr. of Iloilo. As public servants, we took an oath to uphold the people's will at all times. All who hold positions in the government of a republic are accountable for their actions. For the power of the sovereign Filipino people is a power that is higher than the executive, the legislative, or even the judiciary. And therefore, no matter how high and mighty one's position may be, no one can ever be beyond public accountability. Today, we lay down before this honorable impeachment tribunal the product of the collective voice of the people. Impeachment of Chief Justice Renato Corona for betrayal of public trust, culpable violation of the Constitution, and graft corruption is the verdict in the House of Representatives. By issuing such verdict, we took the first step towards the fulfillment of our oath as the keepers of the people's trust. Let me be clear. We are not here to indict the Supreme Court as an institution or to do battle with the judicial branch. We are here to search for the truth so as to restore the strength and independence of the judiciary. We are here because one man, Chief Justice Renato Corona, has bartered away for the pot of porridge the effectiveness, independence, and the honor of the Supreme Court. Mr. Senate President, Your Honors, one very important question before this honorable tribunal is by what standards should Renato Corona be judged? You only have to look at the Supreme Court itself to know the answer. As you climb its steps, you will see two statues. One of these is Cayetano Arellano, the first Chief Justice, a man of absolute integrity and of deepest legal wisdom. The other is Chief Justice Jose Abad Santos, who viewed his oath so sacred and loved his country so deeply. He preferred to die at the hands of the Japanese rather than betray his country. The Supreme Court itself then views the position of the Chief Justice as beyond politics, beyond personal considerations, and always putting one's honor and justice ahead of every other consideration. Pagkatao po ang ating pinag-uusapan dito. The Code of Judicial Conduct demands that the judge must be like Caesar's wife, someone who must not only be pure, but beyond suspicion at all times. A justice, therefore, should be judged according to the highest standards. Against such standards, we then ask, who is Chief Justice Corona? What kind of a man is he? Ano po ba talaga ang pagkatao ni Renato Corona? Chief Justice Renato Corona was a loyal servant to former President Gloria Macapagal-Arroyo from the time she became Vice President in 1998 until she became President in 2001. Such loyalty had numerous rewards for the Chief Justice. Imagine, GMA paid for his back surgery. His wife was given plum positions in the John Hay Management Corporation. He was appointed Associate Justice. And the best reward of all, against all odds, he took a midnight oath as Chief Justice of the Supreme Court. Corona's appointments as Chief Justice also serve an immoral purpose, that of shielding GMA from prosecution for her misdeeds during her presidency. The prosecution will show how Chief Justice Corona became the crowning glory of the cast of accomplices of the former president, and how he protected GMA's interest in exchange for the possession of prestige and power. This is at the heart of Article 1. This unholy alliance between the Chief Justice and GMA and Corona's deep indebtedness to the former president culminated in the issuance of the temporary restraining order to enable GMA and her husband to leave the country and escape accountability. This is Article 7, Corona's biggest favor yet to his benefactor. And in Article 4, we will show how the Chief Justice intervened in the impeachment against former Ombudsman Gutierrez, also to protect GMA's interest. In Articles 3 and 5, we will show the lack of moral fitness of the Chief Justice when he committed acts of impropriety involving parties with pending cases in the Supreme Court. His mockery of the disciplinary institutions of the Supreme Court in the plagiarism case of an associate justice will be proven in Article 6. And in Article 8, we will show how he failed to account for the Judiciary Development Fund and the special allowances for the judiciary, funds which are managed by the Chief Justice. Malinaw po, kung gusto natin ng hustisya, hindi na dapat natin ipagkatiwala kay Chief Justice Corona ang pinakamataas na pwesto sa hudikatura. And finally, we come to Article 2, where the prosecution will prove that the Chief Justice amassed ill-gotten wealth after he was appointed to the Supreme Court in 2002. To give you an idea of this article, let me present to you some of the prized pieces of the Corona crown jewels. Spanish Bay, Bonifacio Ridge, acquired October 2005. Purchase price, 9,159,940. McKinley Hill, Fort Bonifacio, acquired October 21, 2008. Purchase price, 6,196,575. The Bellagio Tower, Taguig, acquired December 2009. Purchase price, 14,510,225. The Columns in Makati, acquired in 2004. One Burgundy Plaza, the building where GMA had a penthouse unit when she was vice president, acquired in 2003. Purchase price, 2,758,000. And number 57, Maranao Street, La Vista, acquired in 2003. The zonal valuation is 20.4 million pesos, sold to his daughter only for 18 million. Your Honors, the governing principle of our laws is clear. Unexplained discrepancy between a public officer's income and his assets, declared or undeclared, is prima facie evidence of ill-gotten wealth. Therefore, an impeachable crime of graft and corruption. The process of accountability is always a painful one, but the legislature is tasked by no less than the Constitution, the very expression of the people's will, to undertake this sacred duty. And if, at this instance, this is how we are called upon to be of service to our country, impeach we must. Mr. Senate President, ladies and gentlemen of the Senate, we submit that Renato Corona, by his misdeeds, is unfit to remain Chief Justice. In closing, the message of the House as the representatives of the people is the same as that given by Oliver Cromwell when he dismissed England's Long Parliament on April 20 of 1653. Before God and country, we say, it is high time for us to put an end to you sitting in that place which you have dishonored by your contempt of all virtue and defiled by your practice of every vice. You are an enemy to good government, as you have sold your country for a mess of pottage, and like Judas Iscariot, betrayed your God for a few pieces of gold. Depart, I say, and let us have done with you. In the name of God, go. Thank you, and good afternoon.
Thank you. May I remind everybody to address parties here in the third person without any personalities. Majority Floor Leader.
Mr. President, I move that we hear the opening statement of the defense.
The counsel for the good Chief Justice is now recognized to make the opening statement.
I'm Eduardo de Los Angeles, counsel for the Chief Justice. Your Honors, my countrymen, good afternoon. During the past few days, prosecutors happily displayed pictures of the Bellagio and a list of some 45 properties. supposedly owned by the Chief Justice, to create the impression that he accumulated ill-gotten wealth. In fact, the Chief Justice owns only 5 of these 45 real properties. Yet the complaint, which contains 8 grounds of impeachment, does not accuse the Chief Justice of acquiring ill-gotten wealth. He is accused of graft and corruption only for refusing to account for the Judiciary Development Fund, or JDF. Even with regard to his statement of assets, liabilities, and net worth, or SAL-N, the issue is whether or not the alleged failure to disclose violates the principle of accountability. The pictures of the Bellagio and other properties and the bloated list of titles are therefore irrelevant to this trial. This impeachment finds its roots in President Aquino's fight against corruption and his perception that the Supreme Court is a hindrance to his quest. He believes that the Supreme Court protects former President Gloria Arroyo. On the other hand, the defense believes that President Aquino is antagonistic to the court because of its ruling in the Hacienda Luisita case. The nobility of President Aquino's fight against corruption cannot be questioned. It is respectfully submitted, however, that in his fight, the President and the Executive Department are duty-bound to scrupulously observe an abiding respect for the constitutional rights of every one of us. The 8 articles of impeachment can actually be classified in 2 categories. First, those that violate decisions of the Supreme Court, and second, those that pertain to the non-disclosure of the SAL-N of the Chief Justice and his alleged refusal to account for the JDF. Let me first address the latter. Complainants accuse the Chief Justice of allegedly refusing to account for the JDF. The documentary evidence will prove the contrary. And with respect to his SAL-N, the defense will establish that in accordance with law, the Chief Justice annually files his SAL-N with the Clerk of Court of the Supreme Court, who has legal custody of such documents. We shall show that the Clerk of Court is restricted from disclosing the SAL-Ns by resolutions first issued during the term of Chief Justice Marcelo Fernan, way back in 1989. In the light of current developments, the Chief Justice has already caused these resolutions to be included in the agenda of the Supreme Court for re-evaluation. With respect to the decisions, the complainants made a tally of selected cases to show that the Supreme Court was biased. This is not so. First, it is not fair to handpick decisions that supposedly favor the Arroyo administration. All the decisions of the Supreme Court must be considered. Second, there are several decisions actually against the former president and her administration. For example, in Islamic Dawa Council of the Philippines versus Office of the Executive Secretary, the Chief Justice himself penned the decision declaring former President Arroyo's Executive Order Number 46 null and void. Third, in any decision, the Supreme Court always bases its judgment on sound legal grounds. Take the case of the Truth Commission. The defense will establish that the Supreme Court was not biased towards the Arroyo administration. Aming ipapakita na tama ang desisyon dito. Nilabag ng Executive Order Number 1 ang Equal Protection Clause dahil ang pag-imbestiga kay Ginang Arroyo ang tanging layunin ng Truth Commission. Moreover, the Supreme Court even suggested a cure for the defect by not limiting the probe to the Arroyo administration. But the Executive Department stubbornly refused to adopt such a simple amendment. The defense will also explain that when the Supreme Court issued a TRO enjoining Secretary Laila de Lima from enforcing her watch list order, the Supreme Court acted in accordance with the Constitution and jurisprudence. Hukuman po lamang ang maaring magbigay ng hold order kapag mayroon ng naisampang criminal case. Ngunit noong panahong yon, wala pang naisasampang criminal case labang kay Ginang Arroyo. Kahit bago pa dito, matagal nang naghain ng reklamo ang akbayan for plunder. Bakit naman po nating sinisisi si Chief Justice? Di po ba't malinaw na ang executive order ay may pagkukulang sa kaso ni Ginang Arroyo? I remember a Secretary of Justice who aimed to rid our country of corruption. His name is Jose W. Jokno. He secured several search warrants and raided the offices and homes of Harry Stonehill, a rich American businessman who was alleged to have bribed government officials. To set an example, Secretary Jokno sought to prosecute Mr. Stonehill. Using the search warrants, the raiding teams seized truckloads of incriminating documents, including a blue book containing the names of the bribed government officials. Yet, after 3 days, the Supreme Court issued a TRO preventing Secretary Jokno from using all the seized documents. Tulad ng marami, nagtaka ako, paano ito nangyari? After I read the decision penned by Chief Justice Roberto Concepcion, I understood. The decision explained that the search warrants were void and the seized documents inadmissible in evidence because the warrants did not specify the things to be seized as required by the Constitution. The Stonehill case is strikingly similar to the crusade of President Aquino. In both, there are crusading officials who want to eliminate corruption. In both, the public overwhelmingly support these officials. In both, the officials unfortunately transgressed the Constitution. And in both, the Supreme Court stepped in and issued adverse and unpopular decisions because its task is to always uphold the Constitution and the Bill of Rights. The House also complains that the Chief Justice betrayed public trust. When the Supreme Court decided on the cityhood of 16 municipalities, the creation of a new district in Camarines Sur, and the conversion of the Dinagat Island into a province. Aba, nakakalimutan na yata nila na sila ang naglikha nitong mga batas na ito. Now that the Supreme Court has upheld what they did, sila pa ang nagalit at nagmamadaling magsampa ng impeachment case laban kay Chief Justice. Ano bang kalukuhan ito? At ito pa po, sabi nila, this impeachment case is not against the Supreme Court, but aimed to make the Chief Justice accountable for his personal actions. All decisions are, however, rendered by the Supreme Court, never by the Chief Justice alone. Isan lamang ang boto ng Chief Justice at hindi niya kontrolado ang ibang mga mahistrado. Each justice votes according to his own opinion. Taliwas sa sinabi nila Congressman Tupas, wala pong voting block dito. Your Honors, in performing its responsibility under the Constitution, the Supreme Court as a co-equal branch of government is now being assaulted and criticized. It is our humble submission that in upholding the Bill of Rights and the Constitution, the Supreme Court and the Chief Justice cannot be considered as obstacles to clean government or to the President's vision to realize his daang matuwid. In upholding the Constitution and in safeguarding individual rights, the Supreme Court and the Chief Justice cannot be considered the enemies of the people. Precisely, they protect individual rights and therefore do not betray the public trust. Today, the House of Representatives and the Executive Department have joined all their might, power, and resources to impeach the Chief Justice. This impeachment sends a chilling threat to the Supreme Court to withhold the exercise of its judicial power and just let the President have his way. Unfortunately, his obsessive pursuit of his goal has at times resulted in the infringement of the law. It has also brought the branches of government into collision, and now it divides the nation. During this crucial moment in history, we fervently pray that you, our honorable Senator Justices, will listen, consider the evidence, and as your solemn oath declares, do impartial justice according to the Constitution and laws of the Philippines. May God bless us all.
Thank you. Majority Floor Leader.
Thank you. Mr. President, we are in receipt of an urgent motion to cite the House prosecutors in contempt of court, filed by Attorney Fernando P. Perito on January 9, 2012. I move that the Senate President rule on the motion.
Is there any objection? There being none, the Chair rules to deny the motion of Attorney Perito. And the reason for the denial is the fact that he has no standing in this court. He is neither a lawyer for the defense or lawyer for a participant in this proceeding. He did not even take the pain of asking the leave of the Senate to intervene, which is in accordance with accepted rules under the rules of court. So ordered.
Mr. President,
Majority Floor Leader.
we are also in receipt of a manifestation filed by the defense on January 9, 2012, stating inter alia that Chief Justice Corona strongly manifests his objection to the prosecution's unbridled dissemination of information or documents which may not even be admissible in evidence or relevant to the case, and his conformity to the authority of the Honorable Impeachment Court under Rule 5 in relation to Rule 18 of the Senate Rules of Procedure on impeachment trials to issue or promulgate any interim or disciplinary measures to enforce and carry into effect its legal mandate. Mr. President, I move that the manifestation be noted.
Is there any objection? There being none, the said manifestation is noted. And may I say this? Under the Constitution, the mandate given is for the Senate to try and decide this impeachment case. No other institution or body can try and decide this impeachment case. The people do not have the authority to decide, to try and decide this impeachment case. And so therefore, may I request some degree of caution on the part of everyone in exposing evidence that ought to be presented in this impeachment court out in the public. The public is not under oath, unlike witnesses that will be presented here. In fact, the members of the Senate, acting as an impeachment court, have taken an oath to hear this case with utmost impartiality, apart from the oath of office that they've taken as senators and legislators. And so, with that, may I ask the forbearance of everybody to forego any discussion of evidence that will be presented in this forum henceforth. The media will be given enough time to be informed of any matter that will be taken up and or presented to this chamber as an impeachment court. We are not litigating this case before the people. We are a representative democracy. We are not a direct participating democracy. We operate through representatives of the people and let the institutions of government devised and provided by the people in their constitution operate according to these tasks and powers granted to them. Thank you. So ordered.
Thank you, Mr. President. One other matter, Mr. President, for the record. Thank you. For the record, we also have before us the January 10, 2012 withdrawal of appearance of Attorney Ernesto B. Francisco Jr. as counsel for Chief Justice Renato C. Corona.
The withdrawal of the appearance of Ernesto B. Francisco Jr., lawyer, as counsel for Chief Justice Renato C. Corona is noted.
Thank you, Mr. President. There being no other business for the trial today, I move that we adjourn until 2 o'clock in the afternoon of Tuesday, January 17, 2012.
Is there any objection? Hearing none, the trial is hereby adjourned until 2 o'clock p.m. of Tuesday, January 17, 2012. So ordered.
Napanood po natin ang unang araw ng impeachment trial ni Chief Justice Renato Corona at mukhang it's proceeding very smoothly at napanood po natin yung mga preliminary events nitong impeachment trial.
At ito nga ay in-adjourn na ngayong araw at magsisimula muli bukas ng alas 2 din ng hapon. Mukhang gusto ng Senate President na magkaroon ng mabilis and smooth na trial.
Na siyempre nagsimula po tayo kagaya po ng judicial trial na mag-enter ng appearance. Siyempre, nagdasal po muna tapos nag-enter ng appearance po yung miyembro ng bawat panel, yung prosecution at saka yung depensa. Pagkatapos po nun ay hininga na sila ng kanilang opening statements. At nagbigay ng opening statement for the defense yung isang abogado na pribado. On the side of the prosecution, hindi po pinayagan ng Chief Justice na yung private lawyer ang magbigay ng opening statement at miyembro lang daw po ng House o ang congressman lamang ang pwedeng magsalita dun sa floor. Kaya si Congressman Tupas ang nagsalita on behalf of the prosecution.
Sa kanyang opening statement, pinaalalahanan ni Senate President Juan Ponce Enrile ang kapwa niya mga senator judges na maging impartial dito sa paglilitis na ito at huwag kakalimutan na bigyan ng due process itong respondent na si Chief Justice Renato Corona.
Nabanggit din ni Senate President Enrile na unique ang nangyayari ngayon because it is rendering or it is seeking justice outside the judiciary. Kumbaga, kakaiba ang nature ng impeachment court dahil hindi nga naman sila miyembro ng judiciary pero hustisya ang kanilang hinahanap kagaya ng sa domain ng judiciary. Kaya sila nanumpa sa isang special oath para ito, gampanan ang special na role na ito to ferret out the truth and render a just decision on the issues.
Nagsabi rin si Senate President Juan Ponce Enrile na determinado siyang matapos itong trial na ito na isinasagawa ngayon ng Senado.
Sa opening statements, talagang nilahad kaagad yung mga pasabog ng prosecution. They enumerated the properties at medyo mabigat po ang halaga nitong mga properties na ito. At syempre kailangan nilang patunayan ito during trial kung totoo po talagang kay Chief Justice Renato Corona ang mga ito. That was after they of course outlined how he is closely related to the former President Gloria Macapagal-Arroyo.
Matatandaan natin, Mark, na ito nga ang naging laman ng mga balita nito nga mga nakaraang araw, itong pagbubunyag ng prosecution team ng isa pa lang yung kanilang binunyag sa media dito sa mga properties na sinasabi nila na ill-gotten nitong si Chief Justice Corona. At banggitin ko lang itong mga binanggit nilang properties. Ito ay sa Bonifacio Ridge, yung sa McKinley Hill, yung Bellagio Tower. Ito yun, ito yung sinasabing 14.5.
At sa La Vista.
Yes. Yung meron pa sa The Column sa Makati, meron pa sa One Burgundy Plaza, at yun nga sa La Vista. Mukhang ito yung sinasabi nila na worth mahigit sa 20 million piso.
Pero in the opening statement of the defense, pinabulaanan kaagad na hindi si Chief Justice ang may-ari nung, but they were referring back to the 45 properties that were listed or that were revealed during the press conference. Hindi po yung nilista lamang or binanggit lamang ni Congressman Tupas. Kumbaga, bumalik po sila dun sa sinabi during the press conference ng prosecution at sinabing hindi po 40 plus. In fact, 5 lang daw po at ang kanilang papatunayan na may kakayahan naman si Chief Justice na bilhin itong 5 property na ito.
Punto por punto rin na sinagot ng depensa sa pangunguna nga ng nagsalita na si Eduardo de Los Angeles ang mga articles o yung nakalagay dun sa articles of impeachment laban dun sa kay Chief Justice Corona. Isa na dito yung issue sa SALN at yung umano'y flip-flopping decision ng Korte Suprema. Kanyang sinabi na ang pagboto ng Chief Justice ay isa lamang dun sa boto ng lahat kasi di ba ang Korte Suprema they vote as a whole.
Tama yun. At sa araw na ito, naganap din yung diskusyon, yung debate at yung pagbaba ng ruling on the motion for a preliminary hearing. Humingi ng preliminary hearing yung depensa at si former Justice of the Supreme Court Cuevas ang nagsalita on behalf of the defense at sinabi nga niya na aside from the verification requirement, ang argumento po ng depensa na due process should be afforded Chief Justice Corona in the form of notice and hearing na kailangan pa rin daw po yun. At syempre, nag-argue yung prosecution.
At mamaya, Mark, yan nga ang ating tatanungin dito sa ating legal expert na makakasama na kung anong ibig sabihin nitong argument na ito.
Tama yon. Pero yung prosecution nanindigan na sapat na yon and the Supreme Court and the Senate President Enrile made a ruling na hindi na kailangan ng preliminary hearing para dinggin pa itong mga argumentong ito at tutuloy na nga sila sa trial. At this point,
yes, kasama pa rin natin ngayon, Mark, ang kolumnista, tanyag na kolumnista ng Philippine Daily Inquirer, Mr. Conrado de Quiros.
And he is joined by the gentleman who joined us earlier, Attorney Joey Bernabe, who's going to give his thoughts on the legal issues presented during this trial date.
Sir Conrad, kayo po, ano po ang opinion nyo dito sa mga naganap ngayong hapon sa unang araw ng paglilitis sa Chief Justice?
I think generally yung takbo ng yung mga arguments ng dalawang panig gives us a sense kung ano yung magiging strategies ng dalawang panig. Actually, parang deja vu nga eh. It's like the old impeachment trial na yung prosecution is relying more on the spirit of the law. Tapos yung defense is relying on the letter of the law. Technical talaga yung position ng defense. You will note na yung kay Cuevas nga, very, very technical. Umpisa niya due process na hindi sinunod. So he raised all sorts of objections. And then later on, kahit si the one who spoke for the defense also is very, very letter of the law ang point niya. In specifying specific charges. Curious lang ako daw sa he rejected yung idea ng 45 houses. Sinabi niya, 5 lang ang totoo dun. I wonder kung ano yung 5 yun because he didn't mention. But he also excluded, I think powerful talaga yung presentation ng prosecution sa mga houses eh. So, in-exclude niyo yun kasi sinasabi niyo wala naman to sa wala naman to sa articles of impeachment.
That's right. Yung ill-gotten.
On the other hand naman, I think yung prosecution did a very fine job working on yung spirit of the law. This man is basically unfit for to become Chief Justice. If you go by the presidents, Jose Abad Santos and everybody else, this guy is unfit basically because of these charges.
I'd like to ask Attorney Joey, balik tayo dun sa yung legal maneuver, yung on the matter of procedure, kung meron bang preliminary hearing o wala, and how both sides argued their cases vis-a-vis the motion for a preliminary hearing. Help us understand what just took place.
Salamat, Attorney Mark. Ang defense team ni Chief Justice Corona ang nagmungkahi, ang nagsampa ng motion for preliminary hearing kasi nga gusto nilang ipakita na yung verified complaint na inihain ng mga kongresista ay hindi nabasa at hindi sufficienteng nagko-comply sa constitutional requirements na kinakailangan para magkaroon ng valid na paghain ng articles of impeachment. Ano itong mga constitutional requirements? Unang-una na nabasa, pangalawa na ang mga sinasaad doon ay totoo at base sa personal knowledge ng mga nagsasampa ng mga facts and allegations na nilalaman ng complaint. Ngayon, ang sabi naman ng kongresista is, teka muna, hindi kailangang lahat ng pumirma necessarily nabasa at ang kailangan lamang ay 1/3 doon sa mga total number ng kongresista ay in fact nabasa at alam na totoo ang kanilang sinasaad sa articles of impeachment.
Medyo bago yung pinasok niyang yung requirement of due process na dapat merong notice and hearing at hindi lamang yung verification per se. Bale, dinagdagan nila yung requirement sa House eh. At mukhang hindi naman in-argue head-on ni Congressman Tupas yung argumento na notice and hearing. But how did you find the ruling of the Senate President on that argument?
Bago ko sagutin yung katanungan, ibabalik ko doon sa sinabi ni Mr. De Quiros. Dahil nga itong ating defense team for Justice Corona, gusto nila very legalistic ang approach. Kaya itong sinasabi nila na due process requirements, one, yung kailangan na merong notice na dapat hinain kay Chief Justice doon pa lang sa House proceedings at pangalawa na dapat may determination of probable cause doon sa House proceedings bago isampa yung articles of impeachment. Yun ay nilalaman sa ating rules of court. Pero wala ito sa Senate Rules on Impeachment. So, tama lamang, para sagutin lang yung katanungan, tama lamang na sabihin essentially ni Senate President Enrile na walang basihan para sabihin ni Justice Cuevas na kailangan itong nakasama, nakabalot doon sa pagsampa ng articles of impeachment ng kongresista dahil hindi naman ito nire-require sa Senate rules. Ito nire-require lamang sa rules of court which only applies suppletorily, parang karagdagan lamang ang kanyang application. So sabi ni Senator Enrile, ang decision niya on the motion for a preliminary hearing, hindi tayo kailangan magkaroon ng preliminary hearing. Tinatanggap niya na ang complaint na hinain ng mga kongresista ay sufficiente at nagko-comply sa saligang batas.
So hindi po kailangan itong preliminary hearing. Ano po ang magiging epekto nito sa trial mismo?
Ang ibig sabihin lang nito ay magsisimula na ang trial proper, which is actually what happened. Nagsimula na ang opening statements for the prosecution at para sa defense.
Sir Conrado, what feeling did it conjure para sa iyo? Did it parang pwede bang pagkatiwalaan itong prosesong ito, and is the Senate President para sa tingin ninyo handling this well?
It's a good beginning. It's too early to tell naman eh. Pero it's good. It's a very good beginning. Pero yun nga, you have to ang interesting doon, I think, yung sabi ni Senate President nung bandang huli, he wants to, parang at the end of the day, it's the Senate that's going to judge this. Well, he has to say that because they're hearing the impeachment. Pero in practice, I think, if you go by the previous impeachment, there's such a thing also as the court of public opinion. It's the people watching these things that are also going to judge this, and the senators themselves, turned judges, are going to be they have to perform well because they themselves are being judged. There's another court out there. There's a parallel thing happening. Ito need not necessarily be opposed.
Ito, Attorney Joey, nakita mo na nag-rule si Senate President na ang mga congressman ang pwedeng mag-litigate dito o magsalita doon sa floor. Hindi pinayagan na ang private counsel or private prosecutor ang magsalita on behalf of prosecution. Ang mukhang, kung titimbangin ang both sides, mukhang napakabigat ng defense team ni Chief Justice Corona. Anong tingin mong epekto nito sa kabuuan ng trial?
Pareho namang mabigat yung team for the defense at for the prosecution. Lamang sa simula pa lang, si Senator Enrile, nag-issue na siya ng kanyang guidelines. Sinabi niya na only the prosecution panel from the House of Representatives, ibig sabihin yung ating mga kongresista, ang pwedeng mag-argue ng kaso. Yung mga private prosecutors naman ay hinahayaang magpresenta ng ebidensya para sa kaso ng mga kongresista. Parang hinati lang niya kung ano yung pwedeng gawin ng private prosecution at saka nung mga prosecution panel.
Ibig sabihin, pakidistinguish po yung mag-a-argue versus magpresenta ng ebidensya. Ibig sabihin ba na pagdating ng trial, pwede nang yung private counsel ang magpresenta gagawa ng direct examination or magko-cross-examine at yung mga congressman pwede na sila maupo lamang?
Doon sa halimbawa mo, pwedeng mangyari ang ganon. Pero dahil dito sa opening statement, ang nangyayari dito, hinahain mo kung anong argumento in favor of the prosecution's case, no? So you are making an argument. So ayon dun sa ruling ni Senator or sa initial guidelines ni Senator Enrile, ang kongresista lamang, part of the prosecution panel, ang pwedeng gumawa nito. Pero tama rin yung sinasabi mo, habang tumatakbo ang trial, depende sa parte ng kanilang ginagawa, kung ito'y nagsisilbing paghain ng ebidensya, nagsisilbing pagkuha ng testimonya ng mga iba't ibang witness, ito ay pwedeng gawin ng private prosecutors. Pero pag oras na kailangan gumawa ng argumentation to make a case in favor of the prosecution, yung mga kongresista lamang ang pwedeng magsalita.
Nakita rin po natin, attorney, na napaka-stricto po sa oras, which is very different from what happened during the impeachment trial of the then President Joseph Estrada. Ano po ang magiging epekto nito sa pagsasagawa nitong paglilitis?
Well, una-una, I think it is the hope ng bawat isa sa atin na matapos ito sa madaling panahon, hindi doon sa nagdradrag ang argumentation at ang mga posisyon ng iba't ibang counsel or at iba't ibang mga testigo. I think it augurs well for the process that we have an efficient impeachment proceeding.
Sir Conrad, napansin niyo po, ang nagsalita lamang si Senate President, si Majority Floor Leader Soto, may manifestation si Senator Kiko, but basically talagang yung dalawang senador lamang ang nagsalita. Mukhang maganda ba ito? At kumpara doon sa nangyari during the time of President Erap, ano ang improvement sa nangyari ngayong araw?
Better time management. Whether it will be good or bad, it remains to be seen. Pero yung tinatanong mo kanina na yung impression na para mas malakas yung mga abogado ng defense. Alam mo, it was the same way nung the first impeachment trial. If you went by, nandun si Joker on one side and some of the congressmen. On the other hand, ang kalaban mo nun, si Estelito Mendoza, si former Chief Justice Andres Narvaza, talagang malakas all the time yung ganyan. So if you notice na what happened then was that yung mga senador mismo became very partisan in their questioning. Sila actually yung like I said earlier, sila yung prosecution and defense. I suspect lang that that's going to happen again, particularly because next year is going to be an election year.
So kailangan.
So we have yet to see po kung talagang magkakaroon pa ng pasiglaban.
Let's see. Kaya tinatanong mo how it will pan out. Let's see in the next. It's too early to tell. Pero okay naman sa akin. I like it na mabilis.
Another benefit that we can get out of this is yung mga tao nga to engage a government at to participate in the public discourse. At do you think this was interesting enough for the nation to follow it all through?
Yes. Ang feeling ko nga actually, if the first impeachment trial was very, very popular, this one can be even more so. Because ang nadagdag ngayon, yung digital It's Facebook, it's all the social media. It's so easy for the public to participate. Non-spectator lang because you just watch TV. Ngayon, nangyayari, susulat na, puro text na yung mga
At napakabilis nga po ng feedback. Basahin po natin ang mga salubin ng ating mga manonood mula sa Twitter, Chloe Barcelona. Dapat lang malaman ng lahat ng tao ang nangyayari sa impeachment trial. Kinabukasan natin ang nakasalalay dito.
Ito, sabi ni Angelica Torres, hindi pa ba sapat ang mga impormasyon na nakikita natin ngayon? Niloloko tayo ni Corona. Naku, talagang mukhang meron nang na-form na opinion ng ating mga kababayan.
Ito naman, mula sa Facebook, Chief Justice Corona, isa kang midnight appointing. Nung tanggapin mo ang posisyon na yan, dyan pa lang sinuway mo na ang isang batas na ang may akda ay ang Supreme Court.
Yan, at galing pa rin sa Facebook, ang babaw ng mga dahilan ni CJ Corona, ginagawa niyang katatawanan ang Korte Suprema. Siyempre, can we make conclusions this early, attorney? Anong tingin mo?
Sa aking palagay, kailangan nating madinig ang ebidensya ng bawat panig bago tayo makakapaghusga talaga sa culpability ni CJ Corona.
Meron pa tayong hindi nabasa mula sa Facebook. I hope justice will prevail. Good job daw kay Zarina. Itong ating reporter sa labas. No?
Tama yun. Mukhang may fan na
may
si
fan
Zarina.
Na siya.
Oo, mukhang magaling yung coverage si Zarina sa baba. Si Zarina. At importante po talagang marinig din ang mga kababayan natin. Ano ang tingin mong nangyayari ngayon sa akademya naman, Sir Conrad? Sa mga taong nag-iisip, sa mga taong nagfo-form ng opinion ng marami sa atin. Are they following this? Are they trying to participate in this?
I'm almost sure they are. Because this trial actually began long before the impeachment. Kasi hindi naman to kayo sa limbawa ng murder na ikaw ba talaga pumatay ng tao o hindi. This is a case that has to do with yung character siyempre, I think a lot of people will already have been following what's happening. Na si Justice has been, sabi nga nung isa, midnight appointee. Nakita naman nila yung naging problema nun sa TRO, pinagtalunan. So a lot of people will already have made judgments one way or the other. It doesn't mean talagang conclusive yung judgments nila. They'll probably wait for this, hear out things, and either the initial impressions will be deepened o mababago. Pero I think hindi naman ngayon lang nag-umpisa yung
Attorney Joey, bukas ay magre-resume uli ang paglilitis. Ano ang maaari naman nating asahan from both sides?
Sa aking palagay, ang mangyayari bukas ay magsisimula ang prosecution na ihain one by one ang mga grounds for the impeachment of Chief Justice Corona. Kabilang na dito yung 8 articles. So, iisa-isahin nila ito at magprepresenta ng ebidensya to support their allegations.
Sa tingin mo ba, Attorney Joey, ang magiging isa sa major clash point ay talagang yung ill-gotten wealth issue? Mukhang yan yung nagre-react ng matindi yung ating mga kababayan. You think that will be a key issue na that could sway this case?
Oo. Marami naman doon sa articles of impeachment ang talagang medyo controversial at talagang pwedeng flashpoints. palagay ko bukas ang magiging topic pa lamang ay yung first article. Oo.
Pero nabanggit ng depensa ngayon pa lamang na hindi kasama sa articles of impeachment yung ill-gotten wealth issue. Kaya anong sa tingin mong magiging epekto nito doon sa presentation ng prosecution?
Kasi kung titingnan mo yung heading or title ng 8 articles of impeachment, tama na wala doon yung sinasabing allegation of ill-gotten wealth. Pero doon sa Article 2, yung sinasabi na hindi nag-file or hindi nagdi-disclose ng statement of assets and liabilities and net worth si Chief Justice Corona, kasama doon sa mga sumusunod na allegations under that heading, nandoon sinasabing may allegation ng House Prosecution Panel na merong ill-gotten wealth, na merong mga nakatagong deposito, may mga bank account na hindi na ilalabas na maaring magpatunay na meron siyang mga nakuhang hindi sa tama o wastong paraan.
So itong mga properties na in-enumerate kanina, it might fall under that.
Yes.
Sir Conrad, itong mga ganitong maagang impresyon, ano po? Dahil we have a process, we are ruled by laws and rules of evidence, at kailangan magdesisyon ng ating mga senador. Pero itong maaga pa lang meron nang na-form na public opinion dahil nga dito sa mga social networking sites. Is this going to be good?
Yeah, well, I think talaga, it's not bad. Kasi it's natural for people to form impressions. I think ay malakas na point na ginawa ng ng prosecution was to say kanina sinasabi ni Tupas. One point that he brought out very very strongly was let's not judge a Chief Justice by the lowest standards. Let us judge him by the highest standards. So that is why he cited ang dapat na Chief Justice is somebody who lives up to the spirit of Jose Abad Santos, tapos Cayetano Arellano. Huwag yung di ba? Parang dapat mataas yung expectation natin si Chief Justice. On that ground alone, I think a lot of people will say, palpak nga itong isang ito. I mean, you can't prevent people from feeling that because pag dinaanan mo yan, what will it prove? Na you're guilty, you're not, okay yan kasi, I think presumption of you're innocent until proven guilty. That's a presumption that has to do with freedom. Hindi ka pwede ikulong unless unless proven guilty ka. Pero if you're aspiring for a position of Chief Justice, hindi lang yan dapat na batayan. Dapat you should aspire to higher standards.
Itong Attorney Joey, na-deny yung kanilang preliminary hearing at yung key argument na binanggit nila doon, yung due process at they cited the case jurisprudence para suportahan na yon. Kung gusto pa nilang igiit ito, anong posibleng recourse nila?
Well, ang defense team could have sought or could seek recourse sa Supreme Court. Ito yung sinasabi ng marami na maaaring magkaroon ng constitutional crisis dahil pwedeng imungkahi ng defense team sa Supreme Court na teka muna, mukhang may grave abuse of discretion, mukhang inaabuso ng Senado or ng presiding justice dahil si Senator Enrile ang hiningan na mag-rule dito sa motion, pwedeng sabihin ng defense team, mukhang naabuso yata ang kapangyarihan. Pero base doon sa nadinig natin, mukhang wala namang ganong tendency or inclination ang defense team na maghain sa Supreme Court ng, let's say, a motion to temporarily restrain the Senate from proceeding with the trial on the basis na hindi maganda o medyo may konting grave abuse of discretion in the exercise of its powers ang Senado.
Okay, maraming
salamat sa ating mga panauhin, Attorney Joey and Mr. Conrado de Quiros.
Maraming salamat.
We will be having them again in the next few days dahil mahabang proseso po ito, hindi lamang po ito ngayong araw. In fact, this is just the start of many more days of trial and we will be hearing information, detalye na po nitong mga ebidensya at hihimayin ito. Siyempre, there will be witnesses to testify on these assertions or arguments. Kaya importanteng tumutok tayo.
In the meantime, Mark, alamin naman natin ang kaganapan sa labas ng Senado. Nandun pa rin ang kasama nating si Zarina. Sarina.
Bagamat tapos ang impeachment trial, patuloy pa rin tayong nakaantabay dito sa labas ng Senado kaugnay nga sa unang araw ng pagdinig sa impeachment case laban kay Supreme Court Chief Justice Renato Corona. Kaya na habang tumatakbo ang impeachment trial, nagkaroon naman ng mainit na sagutan sa pagitan ng mga rallyista at mga kapulisan dito sa bandang Senate Drive. Nagpupumilit kasi mga supporters ni Corona na pumasok dito sa Senado para ihayag ang kanilang mga saloobin. Ngunit hindi nagpatinag ang mga kapulisan dito kasama ang QCPD, NCRPO, MMDA at ang CDM ng PNP Special Action Force. Bitbit nila ang kanilang mga pananggalang. Sa tansya ng otoridad, mahigit 400 na rallyista ang nakiisa o nakilahok dito sa unang araw ng paglilitis kay CJ Corona. Wala namang nagawa mga rallyista kundi umuwi na lamang o mag-back out o tumigil na lamang sa kanilang pagprotesta at bumalik na lamang bukas, sabi ng mga taga-rallyista na supporters ni Corona. At ayun yung pong naasaksihan ang kauna-unahang pagdinig nga ni CJ Corona dito sa Senado. At kung makikita nyo naman na medyo nagkainitan din ang sagutan sa loob ng hall. And then kung mapapansin nyo, 21 senators lamang ang naka-attend ngayon sa unang pagdinig. Isa sa mga absent dito ay si Senator Miriam Santiago kung saan ngayon nakakaranas ng hypertension at isa naman dito Senator Lauren Legarda na inaaruga ang kanyang ina na sumasailalim ngayon sa surgery dahil sa colon cancer. Ang prosecution team naman kung makikita nyo ay kumpleto at nauna na nga dito nagsalita para sa opening statement si lead public prosecutor na si Representative Niel Tupas. At yan po ang pinakahuling balita dito sa labas ng Senado. Balik sa inyo, Kath and Mark.
Maraming salamat sa iyo, Zarina. Nag-uulat pa rin live mula dito sa Senate grounds at kasama pa rin natin ang ating mga panauhin, Gio Tingson. Nagbabalik din.
Amado Valdez, Dean po ng College of Law ng University of the East. Dean, ano po ang inyong tingin sa nangyari sa mga kaganapan sa araw na ito?
Naging mabilis. It's shortened ang proceedings. Palagay ko si Senate President is really brushed up on his procedure. Actually, yung motion for hearing, they proceeded with it. Kaya nga lang, ganun sinasabi ko kanina, yung motion for hearing on their affirmative defense, na there's lack of verification, therefore there's no jurisdiction, etc. Merong idinagdag si Justice Cuevas kanina na issue, yung due process, which is not in their motion yata. The way I see it, hindi, wala sa motion nila, but anyway, it was tackled. And yung very clear naman ang decision, dininay yung motion to dismiss, at very clear yung sinabi ni Senate President na ang impeachment court lang ang may jurisdiction sa lahat ng issues. Kaya wala na tayong dapat pag-alaala na dadalhin sa Supreme Court, kung sino man ang aggrieved party dyan o isang lawyer who is observing and he will bring the case as a taxpayer, o kaya ang Supreme Court dahil may pending case doon, at this point in time hindi na pwedeng mag-issue ang Supreme Court ng restraining order.
Paki-explain nga po nun din, merong abogadong private lawyer ka na nag-file ng
dalawa sila
dito sa impeachment court at meron ding dalawang abogado na merong pending motion before the Supreme Court. Anong magiging epekto nun now that this court has been constituted and has started trial?
Well, yung kung yung tinutukoy mo, meron na gusto mag-intervene dito sa Senate. Hindi naman pwede dahil hindi siya party dito. Pangalawa, yung pending case sa Supreme Court, isang lawyer kasi, usually, as a taxpayer, pwede kang magpunta sa Supreme Court. Kung halimbawa, gaya nito, ginagastos ng Senado yung expenses. So, as a taxpayer, sasabihin mo na hindi ka dapat mag-spend na ng impeachment dahil hindi naman sinunod yung nasa Constitution. So, normally, kung hindi impeachment case yan, pwede mag-assume ang Supreme Court. Pero, it has always been my position at yun na-sustain naman ni Senate President na sila lang ang may jurisdiction dyan.
Alright, babalikan natin yung puntong yan din. Meantime, we turn you over to the briefing room. Meron pong press briefing na nagaganap, panoorin po natin. Ito po nakikita natin.
Prosecution panel.
Yes, tagapagsalita ng prosecution team.
Yes, we'll be bringing witnesses, but probably we'll just disclose it at the proper time. Well, at least dalawa tomorrow. Meron.
What about yung subpoena sa Corona family?
Well, kanina kasi wala sa agenda, sa item of the agenda yon. At we expect siguro sa succeeding hearings, yung, kasi hindi lang yun maraming mga request for subpoena. Kami, may request for subpoena rin kami, and we expect na parang bukas siguro ang succeeding maka-rule yung Senate. Kasi yung natanggap naming notice, meron doon 3 items lang sa agenda. Number 1 is the appearance, entry of appearance of prosecutors and defense. Number 2 is the motion for preliminary hearing. And number 3 is the opening statements from each side. So, thank you, thank you.
Thank you.
Yes, yes, yes.
Okay, thank you. Congressman Tupas will now be leaving us to prepare for a witness, but we will entertain a few questions from the floor. I don't know who's going to preside over this, but sige, who's going to moderate? Yes, pa. We will decide on that tonight, on how, as each day comes na nagbabago-bago, depende sa availability ng biglang dumarating na ebidensya o kaya ng witness. So, as it comes. But we've already narrowed down to at least 2 grounds that we are absolutely ready at this point in time, in fact, which we were ready today to make a presentation.
What are those 2?
Bukas na, ma'am. Bukas na, ma'am. Well, we only had 10 minutes for 8 grounds, covering almost 57 pages nung ating impeachment complaint. So, I mean, necessarily, you'll just have to really glance over the important points. And I think the most important point na sana we don't gloss over is the fact that Congressman Junjun Niel Tupas was able to clearly establish that this is a case of accountability and that nobody is above the law. That's the general theme of his opening statement. And obviously, at the right moment and at the right time, we will present all evidence pertaining to Article number 2 or ground number 2 on ill-gotten wealth.
Also, I'd like to add that we disagree kami dun sa statement ni Attorney De Los Angeles na hindi namin in-allege na may ill-gotten wealth si CJ. Nandun po, kung binasa niyo po yung complaint, under Article 2, yung mga paragraphs doon, andun po yun.
That's just to add to sinabi ni Congressman Sani, no? It's very clear doon sa Article 2, paragraph 2.4, which says that respondent is likewise suspected and accused of having accumulated ill-gotten wealth, acquiring assets of high values, and keeping bank deposits with huge deposits. So we really don't understand where that statement came from. But obviously, it's a precursor. Kung meron tayong nakikita, ito'y paghahanda ng parating ng mga objections na gagawin nila each time may ebidensyang ipipresenta na hindi naman taliwas sa kasaysayan, tulad ng pagpapresenta ng testigo kay Clarissa Ocampo na talagang tinutulan. But let us just stress that today we feel it's a long journey for the prosecution. We are going up against the best trial lawyers, most expensive trial lawyers in town, pinakamamahaling mga abogado. Nandun lahat talaga sa kanila. Pero we are confident that with what happened today, we hope that we'll be able to continue doing as well in the next few days. Ano po yan? I think if I may, we've already issued a statement earlier about kung ano nangyari sa Supreme Court. Gusto lang sana namin linawin na itong ginagawa natin na impeachment ay process of accountability. This is not an attack on the court. Paulit-ulit natin pong sinasabi yan. We are not attacking other judges, other justices. Napakaraming disente at malinis na mga tao dyan. But we are attacking the Chief Justice for his acts over the last 12 years. At siguro, panghuling pwede namin sabihin is,
na nakakalungkot at minsan nakakagulat that the Supreme Court Justice himself, Chief Justice will say na ang pamamaraan lang para alisin siya dyan ay para patayin daw, no? Nakakalungkot dahil parang tila tinutulak pa ang taong bayan na ilagay sa kamay nila ang batas. We don't really expect that from the Chief Justice, who should be the primary and role model when it comes to following the law, actually telling people to violate the law.
Well, when the time comes, we intend to present that we will prove that what he's saying is not true. So we can't go inside. We can't talk really about evidence with the instructions of Senate President. And really, all we can say is that at the proper time, we'll show that what he said this morning is not true.
Like, can they tell us, indeed, Chief Justice holds
We will present the witnesses whom we deem fit and are actually credible. Sisiguraduhin natin yung mga testigong ipipresenta natin ay katanggap-tanggap at kahit kami mismo ay sigurado kami kumbinsido nagsasabi ng totoo.
Well, we're happy that he attended, no? But it shows respect for the court. But we hope he will not just attend. We hope he will also testify because we feel that's the easiest way. Yun ang pinakamadaling paraan para iklaro niya yung kanyang pangalan, i-clear yung kanyang pangalan. Wala namang, sabi naman niya, handa siyang i-clear yung kanyang pangalan. So, nakikita namin kung talagang ganun, ang paraan, sana patotohanin na lang po natin, di ba?
Ang dagdag lang po, ang gusto nga namin, maging kasangkapan rin si Chief Justice sa paglalahad ng katotohanan. No? So, kung ang pag-attend niya ng mga Senate hearings will be the key in showing us the truth, then mas mabuti po para sa atin lahat yan.
Yan ay isang bagay, linawin namin na hindi pa rin nadidesisyonan ng Senado at tingin namin na isang bagay na pag-iisipan o pagdidesisyonan. Pero naniniwala kami at malakas ang aming panalig na hindi papayagan magtago ang ating Chief Justice sa ilalim ng right against self-incrimination. Kung kahit mismo dito sa Senado, ang mga testigo ay hindi pinapayagan, hindi magpakita, pero kung pinapayagan silang i-raise lamang ito kapag tinatanong na sila. Sana ang aming pakiusap at natutuwa kami na si Chief Justice ay nagkaroon ng pagbabago ng pag-iisip pagdating sa pagpunta dito na nagpakita siya. Ang aming lamang pakiusap ay sana ituloy-tuloy niya at magpakita siya sa oras ng panahon na kakailanganin namin ang kanyang testimonya para pabulaanan niya yung iba't ibang aligasyon laban sa kanya. If there's nothing to hide, we don't see any reason bakit hindi siya magpapakita.
Well, depende nga po yan. Naghahain na po kami ng motion for the issuance of subpoena duces tecum ad testificandum sa Senate Tribunal. Hinihintay lang po namin kung ano magiging desisyon ng Senate Tribunal tungkol dyan.
Actually, nag-initiate na po that process. Na-initiate na yun nung nag-file kami ng request for subpoena. Well, I think ready kami whatever the Senate rules on that, no? Kung anong order. I hope not, no? Because if we look at the Estrada trial, hindi naman dinictate eh. It was left to the prosecution.
At saka in common parlance, no, it is really the prosecution who dictates as to which ground is going to be raised, no. So we hope that that's the same route that's going to be followed. But be that as it may, magpapasalamat din kami, syempre. Patuloy kaming nagtitiwala sa Senado. Nagpapasalamat kami na yung dalawang motions na final ng defense na pakiramdam namin ay roadblocks or delaying tactics ay dinispose of in our favor. Nagpapasalamat kami doon. Sana rin, base doon sa kung tinitingnan natin yung mga argumento kanina, meron lang kaming isang pangamba na sana nakikiusap kami na kung titingnan natin lahat ng argumento kanina ni Justice Serafin Cuevas, ay lahat patungkol sa theory behind the law on due process. Sana hindi totoo yung pangamba ng iba naming mga kasama na ito'y panimula para dalhin yung ruling na dinideny yung kanilang motion to dismiss, ay hindi ito panimula na dalhin sa Korte Suprema. Dahil kapag oras na ginawa yan, ay tingin ko isang pamamaraan ng pagtapak sa proseso dito sa ginagalang nating Senado. They can do that if they want to.
They can. It's within their right if they want to. But the question is, it's still the Senate that will decide what to do in the end.
Well, we strongly feel like kapag base kasi sa mga argumento kanina, matagal yung usapin on theory on due process, on probable cause, sa pakiramdam namin bilang mga abogado na ito'y panimula ng pangmahabaang diskusyon na maaaring dalhin sa Korte Suprema. Ang aming pakiusap ay sana wag na, at kahit ang ating Senate President nagsalita na that as far as this matter is concerned, like what the Constitution says, it is the Senate that has the sole authority to hear impeachment cases. Tingin ko napakawalang basihan ito'y para sa amin paghawak lamang sa kung ano-anong bagay na para kumbinsin ng publiko na ang usapin ng pagkakaroon ng good governance at transparency sa ating pamahalaan ay pilit nilang pinauusukan para malito ang taong bayan. Isipin na lang natin yung ruling ng Supreme Court on the Hacienda Luisita case. Yung mga appointees mismo ni President Aquino ay bumoto laban sa interes ng ating presidente. So kung ang ninanais dito ay talagang parusahan o siguraduhin na kontrolado ang Korte Suprema, siguro naman kitang-kita natin ebidensya sa unang 3 pa lamang na na-appoint ay naging taliwas sa interes ng kanyang pamilya dahil ang gusto siguro naman ng ating Pangulo ay magkaroon ng isang Korte Suprema na independent.
Dagdag ko lang po, yung pinapakita po ng Hacienda Luisita case ay pinapakita ang importansya o kahalagahan na mag-appoint ng mga tao sa Korte Suprema na merong paninindigan, merong katapatan, may integridad at walang kinikilingang tao kahit sino man.
Obviously, nililihis ni Chief Justice Corona yung issue at makikita po natin dito, desperate move yan, no? Dahil alam naman po natin ang nakasakdal po ngayon ay si Chief Justice Corona at papatunayan namin, no? Nakaka-insulto rin yan sa mga 188 plus congressmen na nagsampa ng kaso na sasabihin sa kanila na walang basehan ang kaso for impeachment na sinampa dito sa Senate. So sa tingin po namin na ito ay papatunayan namin na walang basehan yung sinasabi po ni Chief Justice Corona at yung mga ebidensya na ilalatag po namin ay magpapakita na hindi po siya talaga nararapat manatili sa hukuman.
Yeah, tulad ng sinabi namin, no, yung mga sinabi nila sa pagdating sa motion for preliminary conference on the validity of the verification, lahat po yun, no? Sinabing there was no probable cause determination, there was no due process because walang notice. Lahat yan ay talagang nangangamba kami na baka ito'y the Senate has ruled on that, and correctly so. The Constitution does not require it. It is a mode of initiation very clearly that 1/3 is sufficient. The probable cause does not need to be determined anymore. When the 1/3 actually decides on the matter, it is as if probable cause has already been determined. We only hope that it's not a preliminary step really on the part of the defense to bring this matter on the verification to the Supreme Court, because to our minds that would be a sad day for our democracy.
Dagdag lang rin, no, yung sinasabi pong due process. Kaya nga meron po tayong trial dito sa Senado. Ito yung pagkakataon kung saan may bibigay ni Chief Justice Corona yung panig po niya. Yan ang due process.
Well, we will strongly oppose that. Pero malungkot 'yon dahil parang kapag ang Supreme Court halimbawa ay mag-issue ng TRO sa proceedings dito sa Senado, ay parang sinabi na rin ng Supreme Court na they are untouchables. So sana naman lang yung kaisa-isang pamamaraan para i-hold accountable embedded in the Constitution ay hindi ibabaliwala ng Korte Suprema. Naniniwala ako hindi nila gagawin 'yon.
Well, sana 15, no? Pero I think that's something that's within the discretion of the Senate to decide. It's along with the other matters. I think they're given under the Constitution, they're given a wide latitude to decide on such matters. Well, hindi ako magugulat kung gagamitin ng depensa yon, di ba? Nakita na natin marami silang taktika na ginagamit at baka gamitin din nila laban dun sa aking ama. Pero sa akin, walang basehan po yon dahil pagka nag-abstain po ang isang senador, parang vote for acquittal po yon. So sana hindi marating sa ganoon at hindi maniniwala sa ganung taktika ang ilang mga senador natin.
At siguro no, yung naipaliwanag na rin namin na pagdating doon kay Congressman San at sa kanyang ama, on many very, very substantive and important points na nakaraan, talagang divergent yung kanilang naging pagboto o posisyon sa mga bagay. Pagdating sa impeachment ni GMA, bumoto si Congressman Sani in favor of impeachment. Pagdating sa VAT, he voted against the value-added tax. Pagdating sa usapin nung pag-i-air out nung Garci tapes, bumoto si Congressman Sani para ilabas ang mga tapes na yon. So, para sa amin din, to be honest, we've also been careful about that matter, but we've seen that we cannot also stop si Sani in terms of having a consistent drive towards good governance dito sa ating bayan.
At palagay ko naman, porque lang bumoto ko, just because pabor ako sa impeachment ni Chief Justice Corona, hindi naman ibig sabihin na automatically pabor din si Senator Angara. In the same way, bumoto si Jackie Enrile, hindi naman siguro pabor si JPE. Hindi bumoto yung ibang relatives ng mga senador, hindi rin naman siguro ibig sabihin na hindi rin sila boboto para sa impeachment. Palagay ko, may sarili-sariling mandato yan, may sarili-sariling isip din po yan.
Nagdidilang anghel ka ba? No, not at all. We just see this today as one small battle. We will deal with this very, very important matter on the impeachment of the Chief Justice as a serious matter. Naniniwala kami that today it was positive for us, but we don't look at it as one bit of a victory. Napakalayo pa ho ng ating laban.
I think klarong-klaro naman yata yung ruling na lahat tayo narinig po natin na the motion is denied, di ba? So, I think that settles it.
Hindi. Actually, meron siyang technical na punto. Kasi kumbaga, ang sinabi is parang, ito sa motion for preliminary conference na para pag-usapan yung verification. So in fact, tinalakay So effectively, the motion was actually granted dahil pinag-usapan, pinagsalita ang magkabilang panig. Pero ultimately, the decision was adverse to them. So ang decision ay pabor sa amin pagdating doon sa motion na yon.
Klaruhin natin, yung prayer of that motion was denied. Yung prayer nila na ma-dismiss yung petition, na-deny po yon.
Okay, siguro panghuli na lang doon is yung mayroong isang particular na ruling na interesting, no, na pinag-uusapan pa namin that we need to also strategize. ay nung nag-rule ang ating Senate President na sinabi ang participation ng private prosecutors ay limited lamang doon sa pagpepresenta ng ebidensya at mga testigo. Gusto sana naming isangguni muna at pag-usapan yan dahil importanteng bagay yan. With utmost respect to the ruling of the Honorable Senate President, we want to tackle that matter because, but nonetheless, I think our public prosecutors showed today that the one who was supposed to argue yung usapin ng verification was actually our lead private prosecutor, Attorney Mario Bautista. Pero dahil nga dun sa ruling, clearly nag-step up the plate si Congressman Niel Tupas. Because in the rules, it's very clear in Section 13, hindi nakalagay talaga doon. Nakalagay doon that counsel of the public prosecutors may appear provided that they work under the control and supervision of the public prosecutor. So, hindi nagkakaroon ng distinction doon. But anyway, that was the ruling there. Nonetheless, binibigyan na namin pagpupugay si Congressman Tupas that he was able to deliver. Pag-uusapan namin because obviously that's very critical for us dahil kita nyo naman po lahat ng mga abogadong nakaharap po ng mga kongresista kanina siguro ay kumakain na sa korte araw-araw yung mga yun, ano, talagang lahat na ata ng mga kilala kong naakusang mga sikat ni-represent nila in the past. So I think it's important for us that we be able to have active participation. Sabi nga namin, if the Chief Justice can choose his battery of the most highly priced defense lawyers, sana naman mapagbigyan kami kahit kaunting mga abogado man lang. Parang, absolutely not. I think that kapag ang katotohanan at ang pinaglalaban ay tama at nasa likod namin, kahit pa sinong higanting legal giant dyan ay kakayanin namin.
Atin po nga natunghayan ang press briefing na isinagawa ng prosecution team dito sa Claro o sa Recto Room dito sa Senado. At sa briefing na ito, inihayag ni lead prosecutor Niel Tupas na bukas ay magpipresenta sila ng at least 2 witnesses.
Nabanggit ni Congressman Miro na masaya sila at na-grant the court ruled in their favor, kumbaga doon sa mga motion na nilahad sa araw na ito. Pero yung medyo malinaw yung pangamba na baka nga isampa sa Supreme Court yung pag-deny ng motion for preliminary hearing. Gusto kong tanungin si Dean Amado ngayon. May basihan ba yung pangamba na yun, Dean? At sa tingin niyo po ba it should cause everyone to worry na meron ng constitutional crisis kung mangyari yon?
Yung pangambang yan is the result of habit Ang habit kasi natin, ang template natin, every time na we are dissatisfied ng isang ruling, punta tayo sa Supreme Court as the court of last resort. Pero dito sa impeachment proceeding, ang court of last resort dito, after the Senate, ang tao. Kaya yung responsibility ng taong bayan ng mga senado dito is with always the thought na kung magkamali sila, babalik rin sila ng taong bayan. And that is the political death sa kanila yon sapagkat kung disgustado ang taong bayan at makita ng taong bayan na nire-road nila, walang due process para kay Corona, baka hindi sila iboto uli. And that is mas masakit yan para sa mga senador who have a lot of ambitions.
Ganito rin ang sinabi kanina ng ating panauhin, no? Yung si Conrado de Quiro, sinabi niya dalawa daw ang korte dyan. Yung isa yung itong korte na ito at isa yung Court of Public Opinion. Balikan po natin kanina yung dinidiscuss nyo bago pumasok itong press briefing. Ito pong TRO na pwede po pa bang magbaba ng TRO?
Hindi na pwede magbaba ang Supreme Court dahil una, nag-assume na ng jurisdiction itong impeachment court at maliwanag do sa statement ni Senate President na ang impeachment court ang merong authority under the Constitution, sabi niya. Hindi rin niya sinasabi yung kundi under the Constitution to resolve all these issues, interlocutory issues dito sa kaso.
The court of public opinion, mukhang nakikita natin sa ating social networking site, hindi lamang doon sa content sila may opinion, pati doon sa form or sa manner by which the participants deliver their speeches. Gio, anong nakalap mong observation or impression ng ating mga kabataan doon sa naganap sa speeches ni former Associate Justice Cuevas, ni Congressman Tupas? Anong tingin nila sa the manner by which it was conducted?
And may I add, Mark, no, si Gio habang ongoing ito ay in touch din siya sa kanyang Twitter account at nakikita niya ang pinag-uusapan doon.
Grabe, unang-una, actually yung general sentiment sa mata, natutuwa sila on how it was being conducted. Parang sabi nga may isa pa ako nakitang Twitter comment na the dignity of the Senate is back because of what's happening right now. Na you're hearing both sides, you're ruling well, and there's an orderly fashion. Pangalawa, pag tinignan mo yung mga sinasabi ng mga tao, naghahanap sila ng post-game analysis.
Okay.
Parang they're looking at parang legal luminaries such as si Dean, kunwari.
So this is what we're doing right now, we're providing them.
Kasi the perception, para mabuo din yung perception, may initial comments, pero pag tinignan mo yung trending, nagsisway siya into even the analysis of or people that we consider as authorities when it comes to forming public perception.
Dean, kanina po sabi ng prosecution team sa kanilang press briefing na umaasa sila na magte-testify itong si Chief Justice Corona. Do you think this will ever happen?
Well, call ni Chief Justice yan na kung inaakala niyang yung kanyang testimony, yun ang mag-change o kaya magkaroon ng hatak para siya ay ma-acquit. Pero alam mo, he has to. Palagay ko ako ang Defense Counsel, dapat ilagay siya dahil alam mo ang handicap ni Chief Justice Corona because this is a political proceedings. Yung handicap niya is the fact that the President who appointed him hindi legitimate nagkaroon ng hearing sa Senate mismo. Yung senador mismo, nakita nila yung how it is alleged na hindi siya ang talagang parang may mga hilugarsi. So merong doubt do sa presidency niya, yung legitimacy niya. So siyang nag-appoint whose legitimacy as president ay doubtful. Yes. Pagkatapos, nag-assume siya and he had the prerogative, call din niya not to accept the appointment as Chief Justice during the midnight ban. But he received it, he exercised it. Kaya yun ang mga handicap niya because in the eyes of the people, yung bakit niya tinanggap yun samantalang may midnight ban at pinus niya the country into a sort of constitutional crisis Kasi kung sinabi ni President Aquino na I do not recognize you as Chief Justice, nagkaroon ng constitutional crisis.
Kat, gusto ko itanong ng kaunti kay Dean, yung procedure na magaganap pa in the next few days. The Senate already ruled on the preliminary hearing at mukhang malinaw, wala nang magaganap na preliminary hearing at hindi na pwedeng questionin yung pag-file ng House. Pero nabanggit din ni Congressman Miro during their press call na yung matter of the preliminary conference. Pakilinaw po ito dito.
Kaya parang mayroong the confusion of terms dyan na napansin mo, ikaw mismo nakapansin kanina, Atty. Mark, kasi yung motion for hearing on the affirmative defenses nila, in effect yun ang motion to dismiss That is another term for a motion to dismiss do sa rules of court. At dininay na yun. Ngayon, yung motion for magkaroon ng preliminary conference, it is an acceptable procedure para sabihin na nyo kung sino mga testigo nyo, ilang minutes magsasalita yan.
So, posibleng bukas
baka ma-realize ni Senate President ng mga senador na kailangan natin ng parang tinatawag na roadmap, mga timetable para makita ng taong bayan kung ano ang agabangan nila, sino magtitistigo kung kailan. At yun ang mga defense counsel, they will have the opportunity to prepare their case na kukrus-examinin pala si Mark, kukrus-examinin pala si Kat. And then, we have a better proceedings sapagkat hindi na yung parang naghahanap ng needle sa haystack yung pagtatanong, hahabol lang yung proceedings.
And yun din kasi ang inaabangan no, ng taong bayan. Kanina nakita natin sa press briefing na yun ang naging tanong ng mga miyembro ng media kung anong mangyayari bukas, ilang witnesses ang ipepresent, anong mga ebidensya. Of course, they couldn't get into details of that.
In fact, kung akong prosecution, that's better, ano? Kasi parang parang tinetelegraph nila yung good faith nila na may fairness on their part na itong testigo namin, ito ang extent ng ebidensya namin during the preliminary conference, and they will be appreciated by the people.
Gio, anong reaksyon ng ating mga kababayan dun sa mga revelasyon so far ng mga property? Yun medyo matingkad sa araw na ito, the value of the properties owned. Hindi pa yung 45 real properties, ano? Bale, ilan lang yung nabanggit Cathy, pero yung value na napakalaki. Ano sa tingin mo ang naging reaksyon nila?
So may tanong na lumabas din kanina nung sinasabi nila, 'di ba, na ang sabi ng prosecution 45 properties. Sabi ng defense 5. So may isang nagtanong kanina, ano yung 5 properties na 'yon? They have yet to be named. Kumbaga, but the reaction is syempre in comparison to salary lagi. Ano ba ang kayang bilhin ng isang chief justice? Ano ba ang salary ng isang tao sa gobyerno? Are you salary grade ganito? But siguro makikita natin sa paglabas nung ebidensya kung ano talaga kung paano tumaas or kung sa kanya ba talaga or yung mga ganitong klaseng bagay. So marami pang tanong na pag tinignan mo yung legal parlance dito, medyo natatanggal yung sindak ng mga tao kasi naiintindihan nila kunwari yung konsepto ng interlocutory order.
Wow.
May naka-clarify siya ngayon, 'di ba? So I think this is very interesting. Day one is very good.
Shocked? Are they shocked with these revelations? Are they revolted? Or nagtatanong lang sila ng detalye at parang tanggap na nila na ganun nga ang magiging kwento?
Kasi lumabas na rin to dati sa media. So nagkaroon na rin ng mga tanong at sagot nung nilabas to ng prosecution. Siguro ang dapat talagang tignan dito ay kung paano ma-develop yung ebidensya when the trial comes, and kung mabigat ba talaga, kasi isang malaking tanong din ay ano ba ibig sabihin nung preponderance of evidence, or paano mo masasabi na may problema dito, may ill-gotten wealth as they were saying kanina.
By the way, ito si Gio ay gustong mag-aral ng kabagasyon.
Din, anong tingin mo?
Kaya curious ako yung sinabi ni yung keyword na sinabi ni Gio diyan, yung development of the evidence, ano. Kasi dito sa properties nito, sabi, very strong ang position ni Chief Justice diyan na 5 lang yung property ko diyan, yung the rest hoax. Alam mo, pag ang nangyari diyan, halimbawa isang property hindi ni-move mark. Na binigay sa iyo ng tatay mo, halimbawa. Yung palang tatay mo gusto niya itago. Tapos nilagay niya sa pangalan mo. So, ngayon, nasa pangalan mo na. Sasabihin ngayon ng tatay mo, hindi sa akin yung kay Mark yan Pero nakalagay naman sa register deed of sale in your favor. So, galing sa kanya. At mapapalabas naman na wala kang kakayahang bilhin yung 20 million worth of property. If there is one property out of that 45 na gano'n ang istorya, tapos na
Isa lang.
Hindi po lahat na
tapos na laban because it would appear na merong cover-up And what kind of Chief Justice you are pag lumalabas na gano'n? I hope walang gano'n.
And
but that is serious. Dapat pag-aralan ng gusto ng prosecutor at mag-research sila ng gusto. I hope walang gano'n. Kasi kung merong ganon, tapos na laban.
Kasi ilan yata dito sa 40 plus properties na ito ay sinabi nga ni Chief Justice nung isang araw ay sa kanyang biyanan. So parang sinasabi niya na nadadamay lang po ito.
Although nabanggit kanina na yung property sa La Vista ay nailipat sa or nasa pangalan ng anak ni Chief Justice, if I'm not mistaken. So mukhang medyo matindi.
Matindi. Lalo na kung yung mga worth 20-30 million na condominium at gano'n na sitwasyon dyan, mabigat, mahirap ipaliwanag yan.
Din, ang issue dito, yung Article 2, is yung SALN mismo. Do you expect the prosecution to immediately ask that this SALN be produced? Malamang bukas?
Yes, kasi halimbawa, kukunin lang naman doon sa who is the keeper there. Hindi naman against the Chief Justice ang subpoena, against the Supreme Court itself, kung sino man ang custodian nun. Hindi naman above the law yun. hide under separation of power, ipoproduce nila yun.
That's right. Maraming salamat po, Dean Amado Valdez at Sir Gio Hingson, Commissioner, National Youth Commission.
At dyan nga nagwawakas, no? Nagwakas na yung unang araw ng paglilitis ng impeachment laban kay Chief Justice Renato Corona.
Nagsimula tayo, Cathy, ng medyo a little past 2 o'clock. Pero napakaganda po ng simula. The senator judges walked into the hall at binuksan ng ating Senate President yung proceedings. Pagkatapos po, immediately after it was opened, Senator Angara said a prayer to officially begin the proceedings at doon na po nagsimula ang paglilitis.
At kanina nga ay dinesisyonan na rin ng Senate President itong motion for preliminary hearing. Ito ay na-deny. At nag-raise din ng isang bagong point itong defense team dito sa motion na ito.
At sa pinaliwanag ng ating resource person, si Dina Valdez, na yung motion for preliminary hearing technically was a motion to dismiss. And denying the motion for preliminary hearing means that tuloy-tuloy na po talaga itong hearing na ito. At na-observe po natin na napakaganda ng conduct ng proceeding so far. Napakabilis, napaka-orderly, at in control po ang Senate President sa proceedings na nagaganap.
Kanina rin ay nagbigay ng kanilang opening statement ang defense at prosecution. Sa opening statement ng defense sa pangunguna ni Congressman Neil Tupas, kanyang binanggit nga itong kanilang mga nakalagay sa kanilang articles of impeachment at nagpakita pa siya ng PowerPoint presentation itong alleged ill-gotten properties nitong si Chief Justice Corona.
Right. On the side of the defense, pinabulaanan kaagad na si Chief Justice ang may-ari nito mga property na ito at pinaliwanag din yung dynamics ng korte kung paano nagdedesisyon to argue that the Chief Justice could not decide on these cases alone at collegial nga yung body at silang lahat ang nagdesisyon at dapat hindi lamang si Chief Justice. Siyempre, yun ang argumento ng depensa. At makikita natin yan na papalawakin nila yan during the course of trial.
At kanina rin matapos itong dalawang opening statement ng both sides ay nag-deny din itong si Senate President Juan Ponce Enrile nitong motion to hold the defense lawyers in contempt. Ito ay inihain ng isang attorney Clarito noong January 9 na kanyang sinabi na ito ay denied dahil hindi naman parte nitong trial itong naghain ng motion na ito.
Although nilinaw po ng Senate President na bawal pong magsalita on matters of defense, on matters directly related to the case, ang bawat panig at kung sino mang senador sa media. At ang pinakamagandang venue, ika nga sabi ng Senate President, ay mismong yung proceedings dahil sila naman po ang magdedesisyon at walang benepisyo kung sasabihin nga sa media ang atong matters of evidence.
At kanina rin ay in-establish na rin ng Senate President itong jurisdiction ng impeachment court over matters pertaining to the trial.
That's right. At mukhang gusto ng Senate President ang mabilis na conduct nitong trial na ito. At sa akin, Cathy, ang napakaganda dito na base din sa impresyon ng ating mga consultants, mukhang it's democracy in action at mukhang napapagana natin ng maayos, at least going by what happened this first day. Mukhang maganda yung pamamalakad. Confident kahit na na-deny yung request ng prosecution na private counsel ang magsalita on their behalf, nagampanan ni Congressman Tupas yung kanyang role bilang prosecuting congressman.
At gayon nga, mabilis na natapos itong unang araw ng paglilitis ng laban kay Chief Justice Renato Corona at bukas ay magpapatuloy ito 2:00 pa rin po ng hapon.
Pinakita po sa screen, there are images of the villages at ng mga building kung saan daw po merong mga pag-aaring unit si Chief Justice Corona. Kailangan pong patunayan, according to our resource person, Dean Amado Valdez, importanteng mapatunayan na lehitimo ang kanyang pagbili ng mga yan. At sabi ni Dean Valdez, kung mapapatunayan na merong pamamaraan na ginawa para itago or hindi maging hindi lumabas na si Chief Justice ang may-ari dito, posibleng yun na ang katapusan ng kaso ng Chief Justice.
At sa dami na ito, no, sinasabi nga ng prosecution team 40 plus itong kanilang sinasabing ill-gotten properties, no, isa lang daw ang kinakailangan.
At mukhang if there is one property that will pin him down, mukhang maapektuhan po talaga yung trust at syempre yung kredibilidad at integridad ng ating Chief Justice. Maganda yung sinabi ni Congressman Tupas kanina na mataas ang expectation ng ating taong bayan sa Chief Justice. At kaya nabanggit niya yung mga previous Chief Justices na talagang yung integridad at credibility ay unquestioned. Kaya dapat yun daw po ang sukatan ng ating paghusga dito kay Chief Justice Corona.
Ito rin ang kanina, no, na nailabas natin dito sa ating diskusyon with Dean Amado Valdez, yung trust ng publiko ay mataas din para dito sa punong mahistrado ng Korte Suprema dahil nga malaki ang kanyang responsibilidad sa bayan, malaki ang kanyang accountability.
That's right. At nabanggit ni Mr. Conrado de Quiros na yung Court of Public Opinion, napakahalaga nun, especially that these senators, judges, are going for elections in possibly the coming years, and they're aware na siyempre nagmamatsyag ang ating mga kababayan, and they're watching closely, and they will see who's deciding the right way and who's conducting himself in a manner talagang befitting a senator judge. Kaya importante pong iparating natin sa kanilang lahat at sa iparating natin through the means of media or social networking sites na we are concerned and we are expressing our opinions.
At nabanggit mo na rin, Mark, itong social networking sites na laman din natin o napulsuhan din natin ngayong araw na ito ang sentimiento ng mga netizens. Yan, tinatawag nating netizens, itong mga karamihan ay kabataan na nagmo-monitor at nagbibigay ng kanilang komento dito sa mga pangyayari sa paglilitis ngayong araw.
Na merong iba nakapunang yung manner of speaking ni Congressman Tupas medyo traditional. Meron namang ibang nagsasabing gusto nila yung ganung sistemang pagde-deliver. At meron ding naka-notice na the defense panel of the Chief Justice ay talagang napakagagaling. Pero I'm sure with the ruling made by the Senate President, the congressmen prosecutors will step up. Wala po silang ibang recourse except to perform according to their sworn duty.
Mark, kanina rin ay nakausap natin ang iba't ibang mga miyembro mula sa iba't ibang sektor. Karamihan sa kanila ay kabataan.
Right.
And I think pare-pareho ang kanilang sentimiento. They're excited to see how this trial will be conducted. Syempre, excited sila na malaman kung ano nga ba ang katotohanan at ano ang magiging desisyon nitong ating mga senator judges kung guilty nga ba o hindi itong si Chief Justice.
Napakagaling, Cathy, na yung questions natin dito, ang sinasagot ng ating mga kababayan, mabibigat. Ano ang ibig sabihin ng hustisya para sa iyo? What is justice for you? These are matters that are serious. Ito yung mga mabibigat na bagay na normally yung mga taga-academe lang, mga taga-opersidad o mga abogado lang nag-uusap. Pero this is an opportunity for all of us to talk about these big things para ma-educate tayong lahat, at kaya hinahatid natin sa kanila yung mga opinion ng magagaling na eksperto para tayong lahat nga ay ma-educate.
At bago tayo magpaalam, Mark, nais lang natin munang pasalamatan ang ating mga naging panel guest ngayong araw na ito, si Attorney Caloy Ocampo, Attorney Joey Bernabe, si Dino Austria, Dean Amado Valdez, Rainier Sindayen, Conrado de Quiros, Gio Tingson at si Carl Santinitigan.
At syempre nagpapasalamat tayo sa ating partner TV stations. Yan po ang IBC 13, syempre PTV4, kasama din po natin ang Radyo ng Bayan, yung local community radio and TV stations, the Philippine Information Agency na tumutulong din sa ating iparating ito sa buong Pilipinas dahil hindi lamang ito para po sa Metro Manila. Ayan, basahin natin ilan sa ating FB and Twitter comments.
At tuloy-tuloy pa rin po ang mga pagpo-post dito sa Facebook. Kahit wala ako sa Pilipinas, parang nandyan na rin ako dahil sa mga live stream ninyo. Hustisya para sa bayan.
Ayan, from Facebook, Corona, stop crying foul. Since the very fact that your Chief Justice right now is foul. Siyempre, itong mga mga conclusion na ito, sana maging based on fact talaga in the coming days.
Ito pa mula sa Facebook pa rin, kapag natanggal ba si Corona ay mako-confiscate din ba ang mga hidden wealth niya? Again, ito po ay nalinaw na ng ating panauhin. Ito pong impeachment trial ay removal from office and disqualification
That's
from
right.
holding public office.
At kung meron mang mga kaso after this process, magdidepende yun kung mai-impeach siya o hindi. Another comment, what does evidence show though? Has he always been pro-Arroyo? I read somewhere he has shown to be pro-Arroyo in rulings. Kaya lang pinapakita din para ng depensa na there are certain matters na hindi nga siya bumoto daw in favor of Arroyo. Pero makikita po yan. Yan po ang role ng bawat panig dito para i-prove sa atin, is he really biased or is he really objective as a magistrate?
Mula pa rin sa Twitter, Linya Zialsita, I hope it's an objective and unbiased. So siguro ang sinasabi niya, objective and unbiased, itong pinanggagalingan nitong mga ebidensya.
Next up from Twitter, ayan, sana po samahan nyo kami. Tuloy-tuloy nyo pong ipadala inyong mga komento at inyong mga katanungan through the Twitter and Facebook pages that we have shown you. Importante din po para masamahan nyo kami ni Cathy as we discuss with these experts. Napakarami po namin natututunan and we're hoping that you're following this. Hindi po ito araw-araw na may ganitong merong prosesong ganito.
At eto nakikita muna natin ang pangyayari sa labas ng Senado. Nakikita natin ang Chief Counsel ng Defense Team, Zarina.
We assess it. But nevertheless, we'll have a conference with the team ko para pagkalahan. Pasensya na kayo.
Sir, gano'n na po kayo para bukas?
Oh, para bukas naman. Pasensya na kayo.
Sir, the
Baka matalo na kami
prosecution
kapopro.
hindi daw sila intimidated sa legal team ni CJ.
Ganon. Hindi naman kami mga terrorist. Bakit kami mag-intimidate sa kanila pabiran?
So, very improper daw yung ginawang statement kanina ni CJ Corona doon sa Supreme Court.
Ay, yun ang hindi ko makuha. Kanyang kwento yun. Mahirap na ako magsabi improper or proper. Siya ang tanungin natin. Salamat ng marami. Okay. Salamat.
Narinig po natin ang maikling komento ni Attorney Serafin Cuevas, Justice Serafin Cuevas, ang Chief Counsel ng Defense Team.
At nakita po natin na napaka-sharp pa rin po, napakagaling pa rin po ni Chief Defense Counsel Cuevas, former Associate Justice ng Korte. At sa tingin ko, Cathy, importanteng magaling ang depensa para kung merong conviction, makikita natin na hindi siya na-deprive ng due process. And he was given all the opportunity to defend and explain himself. Kung hindi din po siya ma-convict at ma-acquit, at makikita din po ng ating kababayan kung bakit hindi siya na-acquit dahil malinaw ang presentasyon ng kanyang depensa. Kaya importanteng both sides do their job really well.
At kanina nga sa interview natin kay Congressman Erin Tanyada, sabi niya ito ay malaking hamon sa kanila, no, sa prosecution panel dahil nga seasoned itong mga lawyers nitong defense team.
Pero ang paniniwala ni Attorney Joey na ating nakapanayam kanina na kaya nitong prosecution panel kahit na po sila ay mga congressman na mag-step up at gampanan yung kanilang trabaho. At sa tingin ko, Cathy, kung talagang matibay yung ebidensya at meron ho talaga silang mga witness na magpapatunay ng kanilang kaso, yung ebidensya will speak for itself. At yung mga witness, kahit na sabihin natin magaling yung nagko-cross-examine, kung talagang magaling yung witness, hindi nagsasabi ng kasinungalingan, talagang lalabas ang katotohanan.
At and with that, magpapaalam na kami ng aking kasamang si Attorney Mark. Magbabalik po bukas ang aming coverage.
Nagpapasalamat kami sa buong team behind this coverage. Tuloy-tuloy po ito ang commitment ng PTV, IBC 13, Radyo ng Bayan, PIA, at sa lahat ng professionals involved in this coverage to give you the best possible coverage we could give you. Kaya sundan niyo po kami, subaybayan niyo po ito at para tayong lahat ay talagang makakuha ng hustisya dito sa Paglilitis.
Muli ako po si Cathy San Gabriel, mabuhay Pilipinas.
At ako po si Attorney Mark Castrodes. See you again tomorrow.